for that. Got it. Well, hello, everybody. It's a lovely Tuesday night. It is May 16th, 2023. And tonight's show, as you can tell by the title, it's finally here. Our gift. So we're going to go and we're going to read some material. What do you think about that? I'm going to probably just open this crazy thing up to you guys. Just make it full blown live. So let me get into this and then I'll bring you on afterwards. How's that? I've got 19 pages, actually 20 pages to read. And I'm sure y'all can hang with me while I go scroll through that. Let me make sure that everything is lined up correct. Oh yeah, there we go. It looks so pretty. I've been waiting for this day, You know, hey, it's not the Fearless Floyd Show unless you get a Christopher Allen Hauser update, correct? So, nope, we're not doing 201 class tonight. But we're live, and I'm going to bring you guys on live. So let's get right down to the bare bones. As you see the seal behind me, that's for our Leafa County, California, de jure assembly. I'll get into that a little later, but I just want to expose it. I'm messing with you guys. All right. I hope you guys are ready, because here we come. Ready or not? Bam! This is it. And I'm just going to blow it up. I've done a little pre-highlighting. What we have here in the Supreme Court of Tennessee at Nashville, April 6th, 2022 session. And that was when the arguments were heard before the full panel of the Tennessee Supreme Court on that date, when all the defendants and the state presented their arguments for review on appeal from the Tennessee Court of Criminal Appeals on appeal from conviction of the Davidson County Court. So the state of Tennessee versus Ronald Lyons, James Michael Usinger, Lee Harold Cromwell, Austin Gary Cooper, and Christopher Allen Hauser. Appeal by permission from the Court of Criminal Appeals. Criminal Court for Davidson County, Cheryl A. Blackburn was the presiding trial judge. As you see, this was filed yesterday, May 15th, 2023, Clerk of the Appellate Courts, filed into their portal, which all I got to do is just click on that tab and boom, I get the update. Here's the update. So I'll read it. The Uniform Commercial Code provides a mechanism for secured creditors to give notice to the world of their security interest in debtor's property as collateral for debt by filling out a form for a financing statement and posting it on the website for the Tennessee Secretary of State. In this case, that system was weaponized. Collectively, the defendants filed over 100 bogus financing statements on the Secretary of State's website regarding over 40 Tennessee residents, including judges, mayors, public officials, law enforcement officers, prosecutors, and ex-spouses. The online financing statements falsely claimed liens for defendants' alleged security interest in victims' property as collateral for millions of dollars in fictitious debt. All were done for the apparent purpose of vexing and harassing the victims. All of the defendants were convicted of multiple counts of filing a lien without a reasonable basis, a Class E felony, and forgery of at least $250,000, a Class A felony. We granted permission to appeal in this case to address the forgery convictions. We hold that the defendant's conduct fits within the statutory definition of forgery. We also hold that the evidence was sufficient to support the jury's finding that the apparent value associated with the fraudulent financing statements was over $250,000. Accordingly, we affirm the judgment of the Court of Criminal Appeals. Boom. Case closed. But the show's not over, because I want to prove to you guys exactly what I said is true. Okay. Nowhere in that syllabus of this rest of this opinion did you see anything about jurisdiction. And one of Chris's key points that he addressed to everybody is, we challenge jurisdiction. I challenge jurisdiction. I challenge her. I made her challenge jurisdiction. Really? Okay, Chris. Well, I proved you wrong. I'm going to prove you wrong again. And I told you, when the Tennessee Supreme Court issues this opinion, because it took them well over 1 year to write this opinion and publish it. And you see what they said when they addressed it. You weaponized the UCC. Okay. Thanks for that, guys. Appreciate you. All right. So we can move on. All right. So when I tell you about these gurus running around out here, sending you all these processes and wasting your time, energy, and money. Okay. Because you can't get those back. Once they're gone, that's good. That's it, man. That's a wrap. And now, because you've been following somebody who's a moron, just trying to steal your money, okay, you're that much further behind everybody else who didn't take that path. So I'm telling you guys out there, and I'm going to go to Lone Wolf, another freaking greedy predator out there. Okay. He's doing a trust class that takes 7 months to set up to teach you how to do a trust. Okay. And you do not have to take my trust class. But if you take my trust class, and Ann's going to teach it to you in 2 days, okay, in less than 4 hours, you're going to get the materials. You're going to get mentors, advisors in a private Telegram room, okay? And we have people in there that write their own trust, go get their EIN number, and go get a non-interest-bearing bank account in 1 week for $199. And they're in with a group of people who've just done that. So they get to move on and do other things. And some of those people take the 201 class and 301 and 401, so on and so forth. Okay. So they all help each other. And that's part of the thing. We're all grow and learn. Okay. This isn't about no fucking ripoff. So anyway, let's continue with the ripoffs. All right. So let's find out the story behind the story that I've been telling you. This is the real Chris Hauser. Okay. That he just keeps going, yeah, I was convicted. Okay, well, here's the truth. Everything he's told you has been baseless lies. And I'm just going to go through this. This isn't my words. This is the opinion of the Tennessee Supreme Court. So if you want to get with somebody, get with all those justices on that court. So here we go. Tennessee Rule of Appellate Procedure. And the reason I know this so well is because Tennessee, all those volunteers came over here and helped stand up Texas. So we adopted a lot of the stuff from Tennessee. So we're very similar. So it's easy for me to roll this off, having litigated in Texas. Anyway, Tennessee Rules of Appellate Procedure, or TRAP, as we say here in Texas, 11, appeal by permission judgment of the Court of Criminal Appeals affirmed. Jeffrey S. Bivens, Justice, delivered the opinion of the court in which Roger A. Page, Chief Justice, and Sharon G. Lee, Justice, joined. Holly Kirby, Justice, filed a separate opinion, concurring in part and dissenting in part, in which Sarah K. Campbell, Justice, joined. Okay, so that means she filed a separate opinion in which she concurred with everybody that previously was stated. Okay, but she dissented into something in what they stated, and we're going to get to that. And Sarah K. Campbell joined Holly's separate opinion where she concurred and dissented. So we'll get into that. Manuel B. Russ, Nashville, Tennessee, for the appellant, Ronald James Lyons. Matthew J. Krieger, Brentwood, Tennessee, for the appellant, James Michael Usinger. Russell E. Edwards, Hendersonville, Tennessee, for the appellant, Lee Harold Cromwell. Wesley O. Wright, Ashland City, Tennessee, for the appellant, Austin Gary Cooper. Martisha L. Johnson, District Public Defender, and Emma Ray Tennant on appeal, and Jared Mollenkoff and Stella Yarborough at trial, Assistant District Public Defenders, for the appellant, Christopher Allen Hauser. Mr. Look, I'm a millionaire. I'm a multi-millionaire. Remember that guy? Remember that video? Public defenders, really? At trial and on appeal? In the Court of Criminal Appeals and in the Texas or Tennessee Supreme Court? I mean, damn, dude, you must really be broke or not how to do anything effectively. That's all I can say. The proof is in the pudding. I can't make this up. I told you guys all about this with Chris Hauser. Okay. Now I'm telling you about Lone Wolf. And you guys listen. Okay. Because this is your fair warning. And I'm going to start having people on my show who are in Lone Wolf's group, who've been disgruntled, got kicked out, got their money taken, got their house foreclosed on, got their car repossessed, got evicted, got their credit card shut down, etc., etc., etc. Okay, so I'm proving it right now, Chris Hauser, that everything I've said in every video that I've done is 100% true, absolutely. Okay, and I hate to beat Chris Hauser up, but bro, when you step out and you want to be that guy, you better have your bona fides in order. That's all I can say. Because when you start shooting up red flags, we're going to catch them. Okay. All right. Herbert H. Slattery, the third Attorney General and reporter. Andrea Sophia Blumstein, Solicitor General. Ronald L. Coleman, Assistant Attorney General. Glenn R. Funk, District Attorney General. And Roger D. Moore, Deputy District Attorney General for the Appellate, State of Tennessee. Opinion. Here we go, kids, because this is what matters. This is the story within the story, within the story, within the story. Because there's a story, a trial, an appeal. Here we are. Factual and procedural history. Defendants: Ronald Lyons, James Michael Usinger, Lee Harold Cromwell, Austin Gary Cooper, and Christopher Allen Hauser were all named in a multi-count indictment by the Davidson County Grand Jury. Collectively, the defendants were charged with 102 counts of filing a lien without a reasonable basis, a Class E felony, and 102 counts of forgery of at least $250,000, a Class A felony. See Tennessee Code, annotated statutes, or sections rather, 39, 14, 105, blah, 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 blah. That's all just mumbo jumbo. Y'all go look those up if you want. The defendants were tried together in a jury trial. The jury found each defendant guilty as charged on all counts. The trial court sentenced defendant Cooper to an effective sentence of 50 years. Defendant Cromwell to an effective sentence of 25 years. Defendant Hauser to an effective sentence of 25 years. Defendant Lyons to an effective sentence of 22 years. And defendant Usinger to an effective sentence of 21 years. To get to the footnotes, boom, that were up here. Right there's a footnote. Defendant Cooper was charged with 10 additional counts by the Davidson County Grand Jury in a second indictment. 3 additional individuals, Michael Robert Birdsell, Victor D. Bunch, and Mark A. McConnell, were also charged in the indictments. They were not tried with defendants and are not at issue in this appeal. 2, Defendant Cooper. There's 2 right there. Boom, Class A felony. Oh, it's close there. Defendant Cooper was charged with 15 counts of each offense Defendant Cromwell was charged with 14 counts of each offense. Defendant Hauser was charged with 21 counts of each offense. Defendant LYONS was charged with 30 counts of each offense, and defendant Usinger was charged with 22 counts of each offense. Proof at trial. The trial in this case included testimony from approximately 30 witnesses, including several of the victims. The victims included persons of prominent public service positions as well as private citizens. Some victims, such as Greene County Clerk and Master K. Solomon Armstrong, testified that they had never met defendants. Others, like former Tennessee Highway Patrol Colonel Tracy Trott, and former Tennessee Department of Safety and Homeland Security Commissioner David Perkey, apparently became targets simply because their names had appeared on official state websites or letterhead. Other victims, however, testified that they had interacted with one of the defendants in an adverse way. For example, in 2016, Morristown police officer Richard Webb wrote defendant LYONS a speeding ticket. Victim Melissa Hauser, defendant Hauser's ex-wife, had taken him to court over child support. Whatever the reason, none of the victims had business dealings or contractual relationships with any of the defendants. None of the victims owed money to any of the defendants. Nevertheless, all of the victims were subjected to the same treatment. One or more of the defendants indicated in a public record that the victim had underlying indebtedness totaling in the millions of dollars and claimed the defendant had a security interest in the victim's property as collateral for that indebtedness. The public record utilized by all defendants was a Uniform Commercial Code, UCC, financing statement called a UCC-1, filed online with the Tennessee Secretary of State. Okay. Yeah, as the court has alleged, of at least $250,000. So they just took a baseline. What actually, some of these, they sued them for multi-millions of dollars, or filed a lien on for multi-millions of dollars. Oh yeah, 5, 10, 15, 25 million, just insanity what these guys were doing. Just total insanity. Just, like, hey, just because Troy Finner's the chief of police of the Houston Police Department, I'm just going to go file this $25 million lien against him because one of his officers wrote me a traffic ticket. Really? That's what's happening. To give the jury background information to understand UCC-1s, the state presented testimony from Director of Business Services for the Tennessee Secretary of State's office, Nathan Burton. Mr. Burton explained that when two parties enter into a loan agreement and the loan is secured by collateral, the lender can file a UCC-1 financing statement with the Secretary of State's office. This process can be done online, Mr. Burton explains, simply by going to the Secretary of State's website and filling out a form. Mr. Burton described the form on the Secretary of State's website. He testified that it lists the name of the person who claims a security interest in the debtor's property, his or her email address, telephone number, and physical address, the name and address of the debtor, and contact information for any other persons who have an interest in the collateral. The filer also must describe the collateral, list the maximum principal indebtedness for tax purposes, of course, and pay a modest filing fee. Once the UCC-1 is filed, he said any member of the public can access it on the Secretary of State's website. It's called the Commercial Registry. Thus, the purpose of the UCC-1 is to serve notice to the world that the person who filed it claims an interest in the debtor's property as collateral for a debt referenced in the statement in the collateral box. Mr. Burton noted that persons who file a UCC-1 must state that they are authorized to make the filing, and they must also acknowledge that it is a felony to file a financing statement without an underlying debt, a security interest. He explained that the process leaves to the filer's discretion the amount of the alleged indebtedness and the description of the property that supposedly is collateral for the debt. The Secretary of State's office does not independently verify purported debts. Mr. Burton described the remedies for an alleged debtor in the event of a contested UCC-1. Individuals who believe a lien asserted against them in a UCC-1 is not valid may submit an affidavit contesting it. Once that is done, the listed secured party is given notice of the contest, and they have 20 days to respond. Mr. Burton testified that if the Secretary of State's office does not receive a response from the listed secured party, either through silence or a return of the notice as undeliverable, it has statutory authority to void the UCC-1 filing. Some of the UCC-1s at issue in the defendant's trial were voided for this reason. Over the course of the trial, Mr. Burton identified 102 different UCC-1s the defendant filed with the Secretary of State's office. Each identification was done much the same way, with Mr. Burton testifying as to the name of the filer, the listed debtor, the listed secured party, and the description of the collateral. In each instance, one of the defendants was listed as the filer and secured party. Generally, each UCC-1's description of the collateral included claim of lien based on a concocted contract or lien in an amount anywhere between $4 and $12 million in the money of account or in lieu of money of account, whatever currency is prescribed as lawful currency for all debts, public or private, in the county in which this claim was executed. The maximum principal indebtedness for Tennessee recording tax purposes section of each UCC-1 listed $0. Here's the footnotes. So if you want to go read that statute, you can right there. Same with that one. Here's footnote 6. Some of the exhibits presented at trial also contained amendments assigning the purported debt to the United States Department of the Treasury. And contained documents indicated the liens were eventually determined to be invalid and the UCC-1s terminated. These facts do not affect our analysis in this case. They were saying it bears no prejudice upon our opinion. Got it? The evidence indicated that the defendant's 102 UCC-1 filings did not happen randomly or by accident. The jury heard testimony from a member of the Tennessee Bureau of Investigation, TBI, Agent Mark Irwin, who was assigned to the Federal Bureau of Investigation's Joint Terrorism Task Force. Let me repeat that, kids. The jury heard testimony from a member of the Tennessee Bureau of Investigation, Agent Mark Irwin, who was assigned to the FBI's Joint Terrorism Task Force. Agent Irwin was the primary investigator into defendant's UCC-1 filing practices. He testified that initially, individual district attorneys reached out to him to investigate potential fraudulent liens filed by each individual defendant. His investigation showed that the addresses where defendants live matched the addresses listed on the UCC-1s. As Agent Irwin looked further into the financing statements, he realized that many of them were filed in the same place at the same time. Based on this, he suspected the filings were done by a group of individuals that were connected. To explain some of the connections and patterns, the jury heard testimony from Michael Robert Birdsell, who was charged in the indictments with similar offenses, but not tried with the defendants. As background, Mr. Birdsell testified he was pulled over in Anderson County, Tennessee by Officer Runyon and arrested. Mr. Birdsell felt that he had been wronged, but he could not find an attorney to take his case. At some point after that, Mr. Birdsell went to a friend to a meeting of a group called the Knoxville Patriots. I'm going to repeat that. At some time after that, Mr. Birdsell went to a friend to a meeting of a group called the Knoxville Patriots, where he said they researched law. At the meeting, he met defendants Cooper, Cromwell, and Usinger. When Mr. Birdsell explained his legal troubles to persons attending the Knoxville Patriots meeting, defendant Cooper responded, "Well, that's $4 million. Mr. Birdsell described the instructions defendant Cooper gave him at the Knoxville Patriot meeting. He said defendant Cooper told him to go home and type up a statement of facts and answer various questions defendant Cooper emailed to him. On one occasion, Mr. Birdsell noted he met Defendant Cooper and Defendant Usinger at the Oak Ridge Library, where he followed Defendant Cooper's instructions in filing UCC-1s on the Secretary of State's website. Mr. Birdsell testified that after following Defendant Cooper's instructions on the UCC-1s, he never received the sizable compensation Defendant Cooper implied he would receive. The jury also heard testimony from victims on the impact of the false UCC-1s filed against them. Attorney Victoria Banach testified that because of the UCC-1 filed by Defendant Cromwell, a potential buyer of her home wanted to pull out of the sale until she explained the purported lien asserted against her was a fraudulent filing. Morristown police officer Richard Webb testified he had to postpone the sale of his house for 4 months until he could get the false UCC-1 filed by Defendant LYONS voided. Melissa Hauser, Chris Hauser's wife, testified that after Defendant Hauser, her ex-husband, filed a false UCC-1 against her, it resulted in the denial of her application for a personal loan and an increase in the interest payments on her car. Attorney Mark Brown testified that false UCC-1s filed against him showed up on his credit report as purported liens on his property. After hearing all the evidence, the jury convicted each defendant on all counts. Each defendant filed a motion for new trial, and the trial court denied each one in separate orders. All of the defendants appealed. The Court of Criminal Appeals consolidated their cases. In a consolidated opinion, the Court of Criminal Appeals affirmed the convictions, State versus LYONS. There's the citing right there. There's your Westlaw citing. That's when it was done, March 22nd, 2021. If you'd like to watch this hearing, it is on YouTube. Go to the Tennessee Courts YouTube channel. Check it out. I did a video on it. And I continue. It concluded that the evidence at trial was sufficient to support the defendant's forgery convictions because the statements filed with the Secretary of State's office falsely claimed the defendants were owed millions of dollars. It also concluded the evidence was sufficient to support the finding that the apparent values associated with the UCC-1s were at least $250,000 because each one claimed a possessory interest in excess of $4 million. Defendants then sought permission to appeal to this court. We granted permission to appeal solely on the issue of whether the evidence was sufficient to support the convictions for forgery under Tennessee Code annotated section 39-14-114. Now, let me repeat that. Defendants sought permission, leave, to appeal to this court, Tennessee Supreme Court. We, the Tennessee Supreme Court, granted permission to appeal, and I quote, solely on the issue of whether the evidence was sufficient to support the convictions for forgery under Tennessee Code annotated section 39-14-114. Does anybody anywhere in that statement see the word jurisdiction? Here. I'm going to give myself a pat on the back. I told you guys, when I get the facts, I will disseminate them and I will prove to you who these charlatans are. And I'm coming for you, lone wolfy boy. Okay, I'm coming. I've got tons of evidence, bro. I got people sending me videos, screenshots. Oh, yeah. Oh, yeah. Oh, yeah. Yeah. Even your your private consults that you've been having, information you're espousing in that. Anyway, let me carry on. Now we're getting to the nitty gritty. The analists, they're going to get anal, right? Anal. All right. waiting for this for a long time. So see, I've been right. And then I have all these trolls, all these doubters, all these, oh no, Chris is God. No, Chris is not God. Okay. Here we go. When a creditor obtains a security interest in a debtor's property, the creditor's interest in the collateral attaches or becomes enforceable against the debtor. And if y'all want, I can read all the citings, or I can just skip right through them. Okay. However, creditors may lose their rights in collateral as against third parties if their security interests are not perfected under the UCC. For the vast majority of these transactions, creditors' securities interest in collateral are perfected by filing a financing statement such as a UCC-1. In order to, and this is a cite from this case right here, this Regions Bank case, that's what this is in parentheses. It's quoting from that case that corresponds with that. In order to perfect a security interest, the security party must file a UCC-1 financing statement. Boom. Okay. That's where it's coming from. The ability under the UCC to create defensible security interest by filing financing statements like a UCC-1, and particularly the ability to file them electronically, revolutionized the system for secure transactions. It allowed the creation of efficient statewide registries that permitted filers to file in one place and creditors to search in one place. There's the code behind it. Requiring financing statements to be filed with the Secretary of State's office. Unfortunately, the ease of the system meant to facilitate painless, secure transactions left it vulnerable to persons with ill motives. Persons disgruntled with the acts of prosecutors, judges, and other public officials have taken advantage of the easy Article 9 filing rules to vent their anger, despite its lack of bona fides. Such as financing statements will be picked up by the credit agencies and may cause the person identified as the debtor to have difficulty getting a loan and to suffer the aggravation and expense of getting the statement removed from the state records. UCC filings are commonly received by filing officers in the Secretary of State's office. However, current Article 9 does not give filing officers discretion to refuse even an obviously inappropriate filing if the requirements in Article 9 are otherwise met. Some courts and scholars have used terms for this conduct, such as paper terrorism. You see all the cases behind that, okay, in all these different states. There's a federal supplement that's from New Jersey. That one's from Illinois. That one's out of the Third Circuit. This one, Missouri. All right. To stem the tide of bogus UCC-1 filings, states have used differing approaches. Pre-filing administrative remedies, post-filing administrative remedies, post-filing expedited judicial remedies, and enhanced criminal or civil penalties. See White and Summers, super. That must be a very predominant case. Pre-filing administrative remedies. See, this is what I said. When I said they pass this around, okay, to other jurisdictions to get their input. That's why it took this long, 13 months, okay? Because they wanted this one right here, rock solid. They want this to be the standard. Boom, this is the one you need to cite, okay? That's when you start seeing these federal sightings in here. That's what they're doing. They're trying to spread the wealth, cover all the bases. It's silly. What's going on there? So anyway, so to stem the tide of the bogus UCC-1 filing, states have used differing approaches: pre-filing administrative remedies, post-filing administrative remedies, post-filing expedited judicial remedies, and enhanced criminal civil penalties. Okay, they did that here in Texas. Pre-filing administrative remedies give the Secretary of State's office discretion to reject a questionable filing, while post-filing administrative remedies give the discretion to correct or remove existing UCC-1 financing statements. Post-filing judicial remedies create a judicial review process for corrective action. They have that here in Texas. Post-filing criminal or civil penalties seek to deter fraudulent filings. They have that as well. It's in the Civil Practice and Remedies Code, Texas Government Code, the Texas Business Commerce Code, and the Penal Code. Got to be penal. Okay, here's your footnote for 7 or 7 right here, paper terrorism. Okay, let's take a look at that. All right, because this is where they're getting it from. One commentator observed, although the perpetrators of this form of harassment do not often try to collect on the liens, their very existence is trouble enough. The liens can create serious financial hardships for victims. Credit ratings are often severely damaged, and the time and expense needed to clear up those liens can be tremendous. Clearing a victim's name and credit can take months or even years, and sometimes thousands of dollars in legal expenses. Joshua P. Weir, Sovereign Citizens, A Reasoned Response to the Madness, 19 Lewis and Clark Law Review, at page 829. This quote from page 857, 2015, footnote omitted, which this is another footnote. So you should all go look this up and go read it. Absolutely. All right. Tennessee has adopted post-filing civil remedies as well as criminal penalties. Pertinent to this appeal for criminal penalties, in 2012, the legislature passed a statute aimed at conduct such as filing sham UCC-1s. It is an offense for any person to knowingly prepare, sign, or file any lien or other document with the intent to encumber any real or personal property when such person has no reasonable basis or any legal cause to place such lien or encumbrance on such real or personal property. Tennessee statutes. All of the defendants were convicted under this false lien statute, and those convictions are not at issue in this appeal. Wow, they're not, because jurisdiction was never questioned. All of the defendants were also convicted under a second nature that makes forgery a criminal offense. The forgery statute has long been in effect and predates the recent increase in the filing of spurious UCC-1s. Those forgery convictions are the basis of the defendant's appeal in this case. The defendants argue that the evidence at trial is insufficient to support their forgery convictions. So this is called insufficiency of the evidence to support the conviction. Okay. And there's a standard for this, and they're going to see right here. Next. Defendants argue at this trial, okay, blah, blah. The court has explained the appropriate standard of appellate review. And I'm sure this is going to be exactly like Texas. Our standard for reviewing the sufficiency of the evidence underlying a criminal conviction is well established. First, we examine the relevant statutes in order to determine the elements that the state must prove to establish the offense. There you go. Elements of the offense. That's why I keep expressing about my DWI. Elements of the offense. Where they first examine elements of the offense. Ding, 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 ding. They're not going to let you win unless they want you to win. That's how it works. Okay, so the State versus Smith, and this is Southwest Reporter volumes, but this is the Tennessee edition. Conducting statutory interpretation of offenses elements before conducting sufficiency review. Next, we analyze all of the evidence admitted at trial in order to determine whether each of the elements is supported by adequate proof. Okay, all the evidence admitted at a trial consists of two things: the clerk's record and the reporter's record. That's it. Nothing else matters. Those two items. That's all they look at. I don't care what else you file, have nothing bearing on what you're appealing to them. All right. So in conducting this analysis, our inquiry is whether, after viewing the evidence in light most favorable to the prosecution, any rational trier of fact could have found the essential elements of their crime beyond a reasonable doubt. Jackson versus Virginia, United States Supreme Court. Okay, that's the standard. Almost every state in the union adopts this standard for sufficiency of the conviction. Okay, and there's a different one for sufficiency of the evidence. It's similar. All right. Findings of guilt in criminal actions, whether by trial court or jury, shall be set aside if the evidence is insufficient to support the findings of guilt beyond reasonable doubt. Well, kids, I just told you they didn't prove all the elements. They didn't allege them. They didn't prove them. So there you go. You're reading it right there. Boom. I'm innocent. Sorry. That's why I said I'll put my car up. Okay, let's read the footnote. As to post-filing civil remedies, Tennessee Code's annotated section 47-9-518 contains a uniform information statement remedy, which allows an individual to file an information statement if the person believes a record was wrongfully filed. Additionally, in Tennessee Code annotated section 47-9-625, Tennessee adopted the Uniform Article 9 remedies for noncompliance, which allow for judicial remedies and damages for a secured party's noncompliance. Finally, Tennessee Code annotated section 47-9-513 lowercase e addresses fraudulent filings against public officials. After a jury finds a defendant guilty, the presumption of innocence is removed and replaced with the presumption of guilt. Consequently, the defendant has the burden on appeal of demonstrating why the evidence is insufficient to support the jury's verdict or judge's verdict, depends on what your trial you had, whether you had a bench trial or jury trial. We, as an appellate court, do not weigh the evidence anew, de novo. Rather, a jury verdict approved by the trial judge accredits the testimony of the witnesses for the state and resolves all conflicts in the testimony in favor of the state. Thus, the state is entitled to the strongest legitimate view of the evidence and all reasonable or legitimate inferences which may be drawn therefrom. The standard of review is the same whether the conviction is based upon direct or circumstantial evidence. On appeal, the defendants first attacked the sufficiency of the evidence supporting their forgery convictions by contending that their actions do not fit the definition of forgery contained in Tennessee Code annotated section 39-14-114. Did anybody in there hear jurisdiction? Crickets? Didn't think so. Second, they argued that the evidence was insufficient to support a finding that the value associated with the UCC1s was at least $250,000. Again, did anybody hear jurisdiction? Frickin' crickets. To analyze these issues, we begin by interpreting the applicable statutes. This court has explained the cardinal rule of statutory construction is to effectuate legislative intent, with all rules of construction being aids to that end. We examine the language of the statute, its subject matter, the object and reach of the statute, the wrong or evil which it seeks to remedy or prevent, and the purpose sought to be accomplished in its enactment. We must seek a reasonable construction in light of the purposes, objectives, and spirit of the statute based on good, sound reasoning. Here's the case citing. Here's what the case is about. Alteration in original, internal citations, quotation marks, and footnotes admitted. The text of the statute is of primary importance, and the words must be given their natural and ordinary meaning in the context in which they appear and in the light of the statute's general purpose, which basically means what it says. We address the defendant's arguments below. Here we go. Forgery, okay? Excuse me. Shouldn't that say jurisdiction? Oh, you challenged your forgery, not jurisdiction, huh, Chris? All right. Well, let's see what he did. Let's see what his public defender did. Tennessee's forgery statute states, a person commits an offense who forges a writing with the intent to defraud or harm another. Seems pretty clear cut to me. The statute defines the key terms, elements as follows. As used in this part, unless the context otherwise requires, forge means to alter, make, complete, execute, or authenticate any writing so that it purports to be the act of another who did not authorize that act, have been executed at the time or place or in a numbered sequence other than was in fact the case, or be a copy of an original when no such original existed. B, make false entries in books or records. C, issue, transfer, register the transfer of, pass, publish, or otherwise utter a writing that is forged within the meaning of the subdivision. Or possess a writing that is forged within the meaning of subdivision B1A with the intent to utter it in a manner specified in subdivision B1C. And writing includes printing or any other method of recording information, money, coins, tokens, stamps, seals, credit cards, badges, trademarks, and symbols of value, right, privilege, or identification. False entries. The parties agree that the relevant statutory definition of forge is to make false entries in books or records. The parties agree the relevant statutory definition of forge is to make false entries in books or records. They all agree. All of the defendants contend that their conduct does not meet the statutory definition of forgery because the liens they filed were not false entries. But not jurisdiction. The main thrust of the defendant's argument is that the statute is intended to criminalize what they call false making. That is, creating a document that is something other than what it purports to be. They argue that the definition does not encompass a genuine document that merely contains false information. According to the defendants, the UCC1s at issue were not forgeries because they were in fact UCC1s and did not purport to be anything else. Citing previous iterations of the statute, legislative history, and the broader context of the criminal code, they argue that the legislature intended the current forgery statute to apply narrowly to only false-making types of conduct. The defendants concede, as they must, that another part of the definition of forge explicitly covers the false-making they describe. As I said when I read the appeal, I was like, oh my God, this is like ludicrous. Why are they even arguing this? They didn't argue jurisdiction. This court has observed that where the legislature includes a particular language in one section of a statute, but omits it in another section of the same act, it is generally presumed that the legislature acted purposely in the subject included or excluded. And I've been through this, okay? So I know this. That's why it's so easy to roll off my tongue. We consider the overall statutory framework and read both subsections of the definition of forge in pari materia. So as to framework and read both subsections in the definition of forge. Oh, I already said that. So as to give the intended effect or effect of both. Sorry, mastered that one. We consider the overall statutory framework and read both subsections of the definition of forge in pari materia so as to give the intended effect to both. So basically what they're saying is they're taking something and trying to harmonize it to get it to where it fits. Reading the false entries provision of the statute in the manner of the defendants proposed would make that definition redundant. Most important, the language in subsection B1B does not support the constraint the defendants seek to place on it. Clearly, the claim made in the UCC1s that they had a valid basis in the form of a colossal underlying debt for asserting a lien and a security interest in the victim's property was false in any sense of the word. The term entry generally means an item written in a record, suggesting it can mean a part of an overall record and not the entire record. Entry, Black's Law Dictionary, 11th edition. There is no indication that the legislature intended this section of the statute to be limited to documents that are inauthentic in their entirety. And that's what they were trying to allege in their brief, that it was they were inauthentic documents. But hold on, we want to file them, but they're inauthentic, so they're not. I think those guys are really confused, don't you? So C, false, Black's Law Dictionary, untrue, deceitful, lying, not genuine, inauthentic, wrong, erroneous, blah, 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 blah. Okay. Take words in natural, ordinary meaning. in books or records. And they break this down, and this is just pretty much a repeat what the Court of Criminal Appeals issued as well. But I'm still going to read it, still going to go through it. We are on page 12 of 19. So Defendant Lyons further asserts that his fraudulent UCC-1s were not entered into books or records as required by the statute. To support his contention, he cites two cases, State versus Pauley and State versus Parrott. In both of those cases, the defendants were convicted of forgery via making false entries in private company records. Forgery of accounts receivables report, and that was in Pauley, and in Parrott, forgery of a company's business records. In essence, Defendant Lyons argues the best interpretation of the statute is that the phrase books or records means only private records of a business and or of a financial nature. This construction is without basis in the language of the statute. There is no limiting language indicating that the records must be those of a private business or of a financial nature. Appellate argues that we should limit the application of the forgery statute to alteration of an existing document originally prepared by a public official, although the only cases interpreting the forgery statute have involved already existing public documents. The statute itself contains no such limiting language. The defendants argue is at odds with the meaning of record. The fact or condition of being, this is the citing from the case, as I told you before, the fact or condition of being or having been written down as evidence of a legal matter. Indeed, the definition of record in Black's Law Dictionary specifically cites the UCC. See record, Black's Law, 11th edition. They don't cite the page numbers. That's sad. In information that is inscribed on the intangible medium or that, having been stored in an electronic or other medium, is retrievable in perceivable form, citing UCC section 1-201B31. Here, under the comprehensive system created by the legislature's adoption of the Uniform Commercial Code, UCC-1s are stored in an electronic medium on the Secretary of State's website and are retrievable by the general public. The filing of a UCC-1 on the Secretary of State's website has a specific legal purpose and effect. Rightly used, a UCC-1 perfects a secured creditor's security interest in collateral and protects it against third parties who might assert a claim against the debtor's collateral. At trial, Mr. Burton from the Secretary of State's office, as you remember, testified that once a UCC-1 is filed, it is stored on a server and added to the database that is made public record on the Secretary of State's website. As Mr. Burton noted, this filing puts the world on notice that the person who filed the UCC-1 may have a legal interest in the alleged debtor's property. The effect on the victims of the phony UCC-1s in this case reflects the fact that the statewide registry on the Secretary of State's website is intended to be a record available for consultation by persons who seek to engage in business transactions. Several of the victims were impacted when members of the public who intended to do business with them apparently encountered the UCC-1s on the website. One victim, a prosecutor who said she only knew defendant Cromwell through prosecution, testified that the UCC-1 he filed affected her ability to sell her house and buy another one once the individuals she was negotiating with learned of the UCC-1. A police officer victim said he could not sell his house until the lien was terminated. Another victim, defender Hauser's ex-wife, testified that the UCC-1 he filed resulted in her bank denying her a personal loan and also resulted in an increase in the interest rate on her car loan. Under all these circumstances, we hold that the evidence is sufficient to support the conclusion that the defendant's conduct in this case falls within the definition of forge contained in the Tennessee Code annotated section 39-14-114B1B, namely, make false entry into books and records. Intent. Let me get a shot here. Intent. The offense of forgery requires that the act be done with the intent to defraud or harm another. Defendants Cooper and Cromwell argue that the evidence was insufficient to show the requisite intent. Defendant Cromwell argues that his name appearing on the UCC-1s cannot be equated to an intent and profess he believed he was following the law. Defendant Cooper argues that filing the UCC-1s amounted to a legal way to address grievances. Intent rarely can be proven by direct evidence. It can be inferred from the character and nature of the act or from all of the circumstances of the case in evidence. Here, the evidence shows that defendants filed the UCC-1s without any legal basis for doing so. The victims had no business dealings with the defendants, nor did the victims owe money to the defendants. Moreover, the evidence shows the false UCC-1s were not filed mistakenly or by accident. The defendants were connected through the Knoxville Patriots group. And in fact, many of the false UCC-1s were filed at the same place and time. Mr. Birdsell testified that at a Knoxville Patriots meeting, after Defendant Cooper heard Mr. Birdsell's grievance against a law enforcement officer who pulled him over, Defendant Cooper responded, "Well, that's $4 million. Mr. Birdsell, along with Defendants Cooper and Usinger, later filed false UCC-1s at the Oak Ridge Library. In addition, some of the victims testified about adverse interactions with one of the defendants, from which rational jurors could infer grievances that motivated the filing of the UCC-1s. The fact that defendants felt disgruntled by something a victim said or did in no way entitled them to seek redress by misusing a legal system for secure business transactions. To Defendant Cooper's point, filing spurious UCC-1s is most assuredly not a legal way to address grievances. The evidence was clearly sufficient for a rational juror to find intent to defraud or harm. Conviction under both statutes. Defendant Lyons argues that the false lien statute and the forgery statute are meant to punish different conduct. Otherwise, the false lien statute would have been duplicative and unnecessary at the moment it was enacted. He contends that the very existence of the false lien statute, tailored to cover the misconduct at issue in this case, indicates that the forgery statute was intended to cover different misconduct. This court considered a similar situation in Welch, which I read. In that case, the defendant was involved in a scheme to enter a Walmart retail store, steal merchandise, and have another person return the merchandise for a gift card. All of this conduct took place after she was banned from the area Walmart stores. The defendant was charged and convicted of a misdemeanor theft under a so-called serial shoplifter statute and also burglary, a Class D felony. She appealed the propriety of the burglary conviction. The court in Welch rejected the defendant's arguments that it was unconstitutional and violated the intent of the legislature to convict the defendant of both theft of property and burglary. The court explained the burglary statute and the serial shoplifter statute prohibit different criminal activities. The two offenses have different elements and punish different wrongs. The burglary statute is applicable to offenders, including repeat shoplifters, who enter a building without effective consent of the owner and commit a felony theft or assault therein, whereas the repeat shoplifting statute is limited in its applicability. There is no indication that the legislature's intent in enacting the serial shoplifting statute was to repeal subsection 39-14-402A3 by implication. The same is true here. The fairly recent enactment of the false lien statute tells us nothing about the correct interpretation of the forgery statute enacted by the legislature many years earlier. Moreover, the statutes contain different elements and punish different wrongs. The false lien statute requires only proof of intent to encumber any real or personal property when such person has no reasonable basis or any legal cause to place such lien or encumbrance. In contrast, the forgery statute requires proof of intent to defraud another or harm another. The false lien statute makes it an offense to knowingly prepare, sign, or file a false lien. The forgery statute, on the other hand, makes it an offense to make false entries in books and records. Other state courts have upheld convictions for both forgery and filing false documents under separate statutes. See State versus Thomason. That's in South Dakota, Louisiana, Colorado, New York, Pennsylvania, Louisiana, California. It is the role of the legislature to declare and define the conduct constituting a crime and determine the nature and extent of the punishment for it. If the defendant's misconduct violates both statutes, they may fairly be punished under both. Identity and filing. Defendants Cooper and Cromwell also argue that the evidence was insufficient to show that they themselves filed the UCC-1s at issue. This argument was without merit. Mr. Birdsell testified that he met both Defendant Cooper and Defendant Cromwell at Knoxville Patriots meetings. Defendant Cooper met with Mr. Birdsell personally to file the UCC-1s, and the UCC-1s actually listed the defendant's home addresses. The evidence was sufficient for a rational juror to conclude that the defendants filed the UCC-1s. Defendant Lyons also argues that some of the UCC-1s that were the subject of his convictions were not filed because the Secretary of State's office eventually rejected them for lack of a valid mailing address. This argument is likewise without merit. Mr. Burton testified that the UCC-1s in question were voted only after they were contested and returned as undeliverable. We agree with the Court of Criminal Appeals observation. This is not the same as a lien never being filed. Therefore, we reject both arguments. Valuation. In the alternative, defendants Hauser and Usinger challenged the classifications of their forgery convictions as Class A felonies for forgery of at least $250,000. They argue that the UCC-1s in and of themselves have little to no value. The state, on the other hand, argues that the forged UCC-1s allege a debt and have some value. The forgery statute, Tennessee Code Annotated, Section 39-14-114, provides an offense under this section is punishable as theft pursuant to Section 39-14-105, but in no event shall forgery be less than a Class E felony. Tennessee Code Annotated 39-14-114C. In turn, Section 39-14-105 provides theft of property or services is a Class A misdemeanor if the value of the property or services obtained is $1,000 or less. A Class E felony if the value of the property or services obtained is more than $1,000 but less than $2,500. Class D felony if the value of the property or the service obtained is $2,500 or more but less than $10,000. Class C felony if the value of the property or services obtained is $10,000 or more but less than $60,000. Class B felony if the value of the property or services obtained is $60,000 or more or less than $250,000. And a Class A felony if the value of the property obtained is $250,000 or more. And if I remember correctly, this was the Class E felony, right? Class E felony right here. Okay, they're saying 1,000 to 2,500, right? Oh no, they challenged the Class A felonies of at least 250. Okay, so they slapped them punk with some Class A's. All right. Yeah, I see that. Up to $4 million. So yeah, no brainer there. All right. The theft statute describes how the offense of forgery is classified for purposes of punishment. Thus, although the statute references property or services obtained, it does not require the defendant to actually obtain property or services in the context of forgery. Rather, forgery is punished according to the apparent value of the writing forged using the value set forth in the theft grading statute. When a determination of value is required to assess the class of an offense, that determination is made by the trier of fact beyond a reasonable doubt. So if there's a bench trial judge, There's a trial by jury. There's the trier of fact. The general criminal law definition of value is found in the Tennessee Code annotated section 3911-106. Value. Subject to an additional criteria of subdivisions A39B through D, value under this title means the fair market value of the property or service at the time and place of the offense, or if the fair market value of the property cannot be ascertained, the cost of replacing the property within a reasonable time after the offense. The value of the documents, other than those having a readily ascertainable fair market value, means the amount due and collectible at maturity, less any part that has been satisfied, if the document constitutes evidence of a debt, or the greatest amount of economic loss that the owner might reasonably suffer by virtue of loss of this document, if the document is other than evidence of a debt. There you go. If the property or service has value that cannot be ascertained by the criteria set forth in subdivisions A39A and B, the property or service is deemed to have a value of less than $50. Well, they went and found it, so they had no problem doing that. The parties in this case have argued the issue of whether the UCC1s constitute evidence of a debt under Tennessee Code annotated sections 39-11-106A39B. In the present case, however, the trial court instructed the jury on the valuation per Tennessee pattern jury instructions, which they covered very well. Specifically, the trial court gave the following instructions without objection by the parties. Quote, for you to find a defendant guilty of forgery beyond reasonable doubt, you must go further and fix the range of apparent value of the property. Apparent value is the apparent fair market value of the property at the time and place of the offense. C, fixing apparent value, 7 Tennessee practice pattern jury instructions. PPI, criminal, Tennessee, penal, something probably. Apparent was defined as visible, manifest, or obvious. Property was defined as anything of value, including but not limited to money, real estate, tangible or intangible personal property. Thus, in order to classify the forgery offenses, the jury was tasked with determining the visible, manifest, or obvious fair market value of the forged UCC1s at the time and place of the offense, when the forged UCC1s were filed in the Secretary of State. The jury also was instructed to indicate which of the following ranges the apparent value of the UCC1s fell within. 1, $500 or less. 2, more than $500 or less than $1,000. 3, $1,000 or more but less than $10,000. 4, $10,000 or more but less than $60,000. 5, $60,000 or more but less than $250,000. Or 6, $250,000 or more. Or number 7, value cannot be ascertained. After receiving these instructions and considering the evidence presented at the trial, the jury determined that the value of each forged UCC1 was at least $250,000. So the trier of fact came through. Our review of the jury's decision requires us to determine whether, viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found that the apparent value of the UCC1s was at least $250,000. At trial, the state presented 102 UCC1 forms the defendants filed with the Secretary of State. In the collateral portion of the UCC1, all of the defendants' UCC1s contain language similar to the following. This financing statement covers the following collateral. Claim of lien number, MJU, that's Michael James Usinger. That's doesn't look like a birth date, but that's some kind of number. Under common law contract. Boom, that's obviously a certified mail number. October 14th, 2016, in the amount of $12 million and no cents dollars. 12 million, there it is right there. Bam. In the money of account or in lieu of money of account, I will receive without prejudice payment in treasury notes, Federal Reserve notes, or a bank draft of the United States dollars or whatever. currency is prescribed as lawful currency in satisfaction of all debts, public and private, in the county from which this claim was executed. I know that was great, wasn't it? So here's the footnote for number 10. Because the jury was instructed without objection to fix apparent fair market value of the UCC1, we do not address whether UCC1s constitute evidence of a debt under Tennessee Code annotated. Okay, they waived it. They didn't object. So that error was not preserved for review on appeal. That's why you hear them object, sustained, overruled, support your objection. A lot going on. All right. Next, although the language used is somewhat garbled, the collateral descriptions were clearly intended to convey, at least obliquely, an impression that the victims owed the defendants underlying debts in the millions of dollars. In addition, Mr. Birdsell testified that when he explained his legal troubles to those attending the Knoxville Patriots meeting, defendant Cooper responded, "Well, that's $4 million. After that, defendant Cooper instructed him how to file fake UCC1s. Mr. Birdsell testified that after following defendant Cooper's instructions, he never got the compensation defendant Cooper implied he would. Where have we heard that? Based on this evidence, we conclude that a rational trier of fact could have found that the apparent value of the UCC1s was at least $250,000. The collateral descriptions in the forged UCC1s and Mr. Birdsell's testimony serve as a basis for a rational juror to infer that the defendants intended for the UCC1s to assert a claim that the victims owed money to the defendants in the amounts equal to or in excess of $250,000 and that the UCC1s had granted corresponding liens against the victim's property. Given this evidence, a rational juror could have found that the apparent fair market value, the visible, manifest, or obvious fair market value of the UCC1s was at least $250,000. Although the evidence is not overwhelming, our standard review does not require it to be. The standard review is highly deferential. It merely requires us to determine whether any rational trier of fact could have found that the apparent value of the UCC1s was at least $250,000. Because we conclude that a rational trier of fact could have made such a finding, we hold that the evidence was sufficient to support the jury's decision as to the apparent value associated with the UCC1s filed by the defendants. Accordingly, we affirm the holding of the Court of Criminal Appeals on this issue. Conclusion. We hold that the evidence in this case was sufficient to support the defendant's conviction for forgery under Tennessee Codes annotated section 39-14-114B1B. We also hold that the evidence was sufficient to support sentencing the defendants for forgery as a Class A felony. Accordingly, we affirm the holding of the Court of Criminal Appeals on both issues. Jeffrey S. Bivens, Justice. Yeah, I know. I know. You're just heartbroken, aren't you? I know I was. Where's the other one? Okay. Are you ready? Page 2, kids. In the Supreme Court of the Tennessee at Nashville, April 6, 2022, filed May 15, 2023, the Court of Criminal Appeals, State of Tennessee versus Ronald LYONS, James Michael Usinger, Lee Harold Cromwell, Austin Gary Cooper, and the illustrious Christopher Allen Hauser. Criminal Court for Davidson County. Judgment. This case was heard upon the record on appeal from the Court of Criminal Appeals, application for permission to appeal having been heretofore granted, and briefs and arguments of counsel. Upon consideration thereof, this court is of the opinion that the judgment of the Court of Criminal Appeals should be affirmed. In accordance with the opinion filed herein, it is therefore ordered and adjudged that the judgment of the Court of Criminal Appeals is affirmed. It appearing that the appellants are indigent, the costs of the appeal are taxed to the state of Tennessee because they are indigent. Because Chris Hauser is broke. Chris Hauser's not a multimillionaire. Now, you read all 20 pages with me, right? I don't know how many words were in those 20 pages. Did anybody hear or see jurisdiction once? Now, I don't know what else to tell you guys. Okay. I've been telling y'all what's happening. And that's what's happening. So, who wants to hop on the gravy train, come ride with me and shoot the shit? Well, I got some gamers over here. I have not been looking at the chat. All right, John. Back over here to Zoom. So you guys want to come on and kick it with me? The link is in the chat. If you like the video, like, subscribe, share, hit the notification bell, do whatever you want. Go to Chris's page and check him out. But I'm going to give you fair warning. I have a bunch of exposés coming out on Patrick Marino, Patrick's own voice, Patrick's own words, administrators, moderators in his group, former students, former moderators, former administrators. I've got a list I've been putting together. So don't think I just like thought this up one day, a couple days ago, and said, "Oh, hey, I'm going to go get with Patrick Marino." No, bro. I've been building a dossier on you, and I got you. Got you. I'm tired of you ripping these people off. I tried to warn y'all guys months ago. Okay. You're doing anything for 7 months, paying somebody, anybody for 7 months for something, you're lost. You're lost. Sorry, you're lost. You need to go get found. You need to sit back, take a breather, and do something else. I'm serious. Can't express that to you guys enough. Some of the things I'm addressing regarding to the county. I spoke with a very well-established, I'm going to call them an assembly today, and we had a very fruitful conversation. So I will be reaching out to other established assemblies and other individuals and groups of people, and because we're putting this together, folks. I don't understand. I don't know if you guys really comprehend what we're doing, but it's the real deal, you know. I'll sure. Let me pop this up just to show you some of the stuff we're working on. Right here, I didn't even work on this. You spin this. This is something somebody else put together in another group, and I'm really not privy to any of this stuff, but they sent me this just so now I wanted to show you that this stuff is already being established. These different entities are being established to do all this stuff. Okay, now I'm gonna flip it a couple times. There you go. This is what the embassy looks like. To all the people who are running the embassy. And this is just for the embassy. Okay. Flip it again. And this is basically a SOP. Standard operating procedure for whatever position this is. Job title, ambassador, chief of mission. Okay, so there's a ton more of these things for whatever it looks like to create a county. I can only tell you guys what I've only done, what I've been involved in. This is what I wrote. This is my contribution. I'm not trying to get off topic here. And this is Khalifa County Judicial Criminal Justice System. And this is everything from the Chancery Court Division, Circuit Court Division, Appellate Court Division, Probation Department, Bonding Agency, Law Enforcement and Structure, which includes the Sheriff, the Court Martial, Bailiff, Constable, and Police Department. And this breaks it down. Here's your Chancery Court Division personnel. There's your, the Chancellor, Chancery Court Clerk, Court Reporter, Chief Court Martial, Bailiff, Court Martial, Bailiff, Master in Chancery, Chief Court Liaison, Deputy Court Liaison, Circuit Court Division personnel. Circuit Court, there's your judge up here. That should be judge. Got to fix that. Circuit Court Clerk, Court Reporter, Court Martial, Bailiff, Chief Court Liaison, Deputy Court Liaison, Appellate Court personnel, Appellate Court Justices. There's 3 justices. There's a Chief Justice and 2 Associate Justices. Each of the Associate Justices is over the Chancery Court, and the other one's over the Circuit Court. Chief Justice is the splitter for the panel to determine if any opinions need to be reheard. Appellate Court Clerk, Legal Secretary, Paralegal, Legal Researcher, Court Reporter, Audio Video Technician, which will everything will be able to be conducted online, will be recorded, and we will have a communications room. I think my dog needs to go outside. Court Martial, Bailiff, Chief Court Liaison, Deputy Court Liaison, Probation Department, Chief Probation Officer, Deputy Chief Probation Officer, Probation Officer, Probation Aide, Bonding Agency personnel, Chief Bonding Officer, Bonding Administrator, Forfeiture Officer, Law Enforcement Structure, Sheriff, Court Martial, Bailiff, Constable, Police Officers. So here's the Sheriff's Office. The Sheriff, Under Sheriff, Captain, Lieutenant, Sergeant, Deputy Sheriff, Investigator, Forensic Specialist, Record Specialist, SWAT Division, Liaison, Public Information Officer, County Jail Structure, Jail Administrator, Jail Sergeant, Correctional Officer, Court Martial, Bailiff, Deputy Chief Court Martial, Bailiff, Court Martial, Bailiff Sergeant, Court Martial, Bailiff, Constable's Office, Constable, Deputy Constables, Administrative Staff, Field Officers, SWAT Division, Police Department, Chief, Assistant Chief, Captain, Lieutenant, Sergeant, Officer, Investigator, Forensic Specialist, Record Specialist, SWAT Division, Liaison, Public Information Officer. This isn't static, it's dynamic. This was created just to get this county stood up and moving forward. So all these positions won't be filled immediately, just a skeleton crew to get this up and running. So basically that's what we have. We still need more people to volunteer and come in and help us out with different positions. But we do have requirements for all of this stuff. Annual physical fitness testing, because there aren't no fat law enforcement officers. Okay, because nobody should be breaking the law. If you're breaking the law, you got some serious issues to deal with, and that's not the community that we want. That's not the community that we want to create and invest our time and energy in. So anyway, this meeting I had earlier today was like very, very, very fruitful, and I think we're going to make some headway. So I was really appreciative of that. But you know, that's just what I've been working on. Of course, the seal, what you see over here. We created that. For those of you who don't know, and I'll explain to you, this is Califia, and California was named after Califia, and it's Calafia. And she is a fictional character from a 1510 novel. She is the queen melanated warrior of an island of women warriors off the coast of Asia. And that's pretty much her story in a nutshell. And as I said, California was named after her. So this is why we chose this. Of course, the purple for the royalty, and then the sun for, you know, California. So that's how this was created. So yeah, and this is going on the license plates that we have done. Those of you who don't know, we are already recorded with the California Department of Motor Vehicles. Our alpha characterization designs have been approved and acknowledged by the DMV. So the national plates for members will be AAA-00000 and ending in ZZZ-99999. The diplomat plates will begin CAA-00000. They will end at CAZ-99999. So once this goes on, and I've already done just a dummy design for it already. I posted it in my Telegram for you guys to go look at. So I don't know where that is right now, due to the fact that the founder did have some health issues that she has addressed. So thank God we are moving forward. And I am moving to that's why they're not there, because yeah, right. Yeah. So anyway, you know, that's what's going on with the county. We're not there yet. And the reason we're not there yet is because this is what this looks like. Okay. You have an established county that's been there for 100 years, something like that. Okay. Now you have some person coming in telling them, sorry, you don't own this land anymore. Either join us or hit the highway. And they're like, what are you talking about? Who are you? So that's what's going on. So what is happening is a part of Riverside County, California, which is the largest county in California. Go look it up on Wikipedia so you can see how large it is. It goes from Nevada almost to LA and contains Joshua Tree. So inside that big ass county are over 48,000 acres that are now Califia County, California. However, there's nothing yet established to show the demarcation borderlines of what that county area is. So we're developing that. Once we have that established, now we can address who the current inhabitants are for that area. Once we identify those, we'll develop the public announcement and all the advertising and marketing materials that will be able to do a press conference in Riverside County live as well as press releases, public notices in that area of paper, mail outs, as well as infomercials. So that way everybody will be notified at the same time, at the same day. And of course, invitations will be sent out to all the current Riverside County administration staff to have them come so they can be a part of it. So there is an agreement that now you've just ceded, okay, this land because it wasn't yours, it's somebody else's. So that's going to, you know, as we all know, that's hard for people to digest. It's, you know, and absolute power rarely cedes power, right? So that's what we're looking at. And that's the hurdle that we have to get over. So when we do this public announcement and this press conference and do the press releases, okay, all the the presentation package that we have that we're going to present, whether it's in digital format, or it's in physical analog format, whatever that looks like, to give to the media, to put on the website, to do a documentary about whatever. It has to be absolute beyond a doubt. When everybody reads it, they're like, wow, holy crap. Whoa. Yeah, it's all hers. Okay. Because when you go through that presentation, it has to be no doubt. It is what it is. And that's the goal. That's what we're aiming for. That's why I'm not coming out half stepping with this stuff. Okay. I'm sharing with you guys because you're already in the community. You already know what this is all about. So this isn't anything new to you. But for the uninitiated, it's going to be quite the shock to, you know, and I'll break it down to you guys. This gentleman right here, Joey Ramirez, running for city council here in Houston, sat down next to me at my at the movie I was in, The Squad, the screening that my friend Juan C. Vasquez made. I'm actually in the movie. I'm at the very end of it, but I'm in the movie. I know I didn't. It was a surprise to me too. Anyway, so this gentleman came and sat down next to me. And I, you know, I see his little vote card on him, and I'm gonna get pitched to go vote. So there's like nobody on my row. Cass is in front of me. He sits down next to me. I'm like, okay, great. So, you know, being friendly. Hey, how you doing? You know, my name's Floyd. Oh, my name's Julian. I'm running for city council. He hands me his card. Well, here we go. And I look at it, and it doesn't say Democrat or Republican. It doesn't say conservative or liberal. Just pretty much standard political card. But he's running for an at-large position with the city council. No, at-large one. And so we start talking and interacting, and you know, he telling me who he is. Hang on, Rick, and I'll let you in 1 second. Let me finish the story. And he says, yeah, I retired in 2016, and I ran for district judge for the 332nd District Court here in Harris County. I'm like, really? Huh. Wow, that's cool. I go, what'd you do before that? He goes, I'm a former 27-year veteran at the Harris County District Attorney's Office. And I'm like, really? Huh, no shit, right? I go, and you retired in 2016? Uh-huh. I'm doing the math in my head. Okay. Wow, never faced him, doesn't recognize him. So I started picking his brain. And he's telling me that he ran for district judge and lost. Now he's running for city council. And if he loses this, he's not going to run anymore. He's not going to be that career guy, chasing the elected office. I was like, okay, that's admirable. That's good. So are you a Republican, Democrat? I can't tell. And he goes, well, the position I'm applying for or running for, it's not Democrat or Republican, but I am a conservative. And I was like, oh, okay, cool. So he gave me his views, kept talking. I'm thinking to myself, oh boy, this is an interesting conversation. I can't even believe this guy sat down next to me. So I asked him a question. I go, you worked for a for-profit corporation, right? And he's like, yeah, I guess so. I'm like, well, you did. And I can prove it. But do you know the difference between a de jure government and a de facto government? And he looked at me and then he turned his head, thought about it. Like, no, I can't say I do. That's interesting. That's very interesting. This guy went to college, went to law school, practiced law for almost 30 years, and then wanted to be a judge, but didn't know the difference between de facto and de jure. Didn't even know what it meant.
I'm more educated than a judge. That's crazy.
I want to be judge. Yeah. I mean, it's almost a 30-year veteran. Yeah. Yeah, that's what I'm trying to tell you guys. Okay. The education you get in this community, it's priceless. I've forgotten more law than most attorneys practice in their lifetime. Absolutely. It's just insane, guys. So anyway, he didn't know the difference. So I was like, I said, well, I guess if you don't get elected, I might have something for you, an opportunity. You never know. He can't hold office, okay? Because you cannot be a prior bar member. You have to have 25-year disassociation for any bar membership before you can hold office in Califia County. Yeah. We don't want the barristers. However, as an advisor, a consultant, or somebody who's, worked the room, yeah, could be a fit. I don't know. That's further conversation. But when I left that gentleman, as he was leaving early, I promise I'll have another conversation. That's what I told him. So I always keep my promises. So Rick Smith, I see you you dove on for a second and peeled right off. I wanted to finish that story. That way, when you come on, I can effectively have a communication with you. Bob was sentenced to 25 years. I don't even know who Bob is. There's my boy Clint getting down. I see you, dog. I invited you to come on the show. I don't know why you don't. Love to have you. So, hey, anyone guys want to jump on, man? Kick it. Kick it. If not, I've got stuff to do. I've got phone calls to make, conversations to have, babies to feed. Yep. So there you go, kids. There is your Christopher Hauser opinion issued by the Tennessee Supreme Court yesterday, May 15th, 2023, which is like 390 days after the hearing on April 6th. So how do you get on here? Shit, bro. Bam. Click that link. Should get right on. Pardon? Internet's tripping. No, it's not. I'm waiting on Clint to join. All right, staging solutions. Man, I love going to work, working like an hour, hour and a half, 2 hours, and fail and get paid for 6. That's love. Love my job. I wish we made more an hour, as we should, but we don't. So it is what it is. All right, Clint. Is that link not working? Yeah, Jesse's in the background. Me and Jesse. Cheryl Williams. Bob the Builder. Bob the Builder got 25 years? What? No. Oh, no, there he is. Chris was arrested for discharging debt with negotiable instruments and something else. No. Chris was convicted of forgery and filing fraudulent liens. And this is the story. Okay. I'm going to give you guys the story of what happened. And if you'd like to read the story, you can go read it at the Tennessee Court of Criminal Appeals website. And you can read the record, okay, which is the opinion of the Court of Criminal Appeals. And in that case, Christopher Hauser paid one of those defendants, I forget which one, $6,500 to file fraudulent liens against his ex-wife, Melissa, his now ex-wife, Melissa, her attorney, I think the judge in the child support case, and I can't remember who else, but anyway, filing, I guess his own wife. So this clown filed these liens, okay, and then apparently Chris filed additional ones because he got 22 counts. Following these fraudulent liens. So he paid somebody $6,500 to file those liens for him because Chris didn't know anything about filing UCC-1s or the redemption process or 1099s. He didn't know any of that. Okay. He stumbled into these guys, these sovereign citizens, admitted sovereign citizens in court. They admitted they were sovereign citizens because there was a recent incident in Knoxville with some sovereign citizens, and they wanted to change venue to get into a different county because of all the media attention addressed to the sovereign citizens, and they were already claiming themselves to be sovereign citizens. Absolutely. Okay, go look it up. I'm telling you guys, on the record in court, I'm a sovereign citizen, I'm a sovereign citizen, na, 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 na. Right? So anyway, that's what Chris did. So Chris didn't know anything about nothing following these ding dongs. So boom, just because he's associated with these guys, he has this aura of he's a sovereign citizen. He knows about the redemption process. He knows how to file those liens. He knows. So when you get into prison, okay, and you have that notoriety, that aura of, the ticket out of here, you're going to get all the attention you want, okay? And you just got to play it off like you know what the hell you're talking about. And you're going to win. And you got to be very secretive. And then they're going to start sharing their information with you. And before you know it, you got 5, 6, 7, 8 guys sharing information with you. But that guy don't know anything about this guy's information. So I can take this guy's information. I can give it to that guy. So that guy thinks I'm giving him my information, but it actually belongs to this guy. And I can do the same thing with this guy. Before you know it, they think I'm a fucking genius. That I know everything. But I don't know shit. I just got a bunch of information. Okay. I don't know what happened to me, except I understood it. I just didn't know what to do with it. I didn't know where to send it. I didn't know what, as we all know, what do you write in this box? How do I spell my name? How do I write it? All capital, lowercase? I don't know, man. I'm confused. Can anybody help me? No. Okay. Can't pick up the phone and call somebody. No internet. So that's what happens when you're in prison. So he gets to prison. Okay. He's got all these people just clamoring around him, thinking he's got Mr. Hotshot. So they start sharing all this information. So that's where he stumbles on to the 1099 process, which I showed you guys I had when I was in prison from, what was it, 2004? So yeah, like 2004, 2005, 1099A, it's dated. Hey, what's up, brother? And let me finish this story real quick. So I had him back then, brought him out of prison with me, and have posted them on here. So it's not a new thing, never has been a new thing. And most of these people who've been in this for over a decade can clearly tell you about all the people who did the 1099 OID process and went to prison. Okay, so this ain't nothing new. So that's where Chris learned this process. Now, I cannot say for a fact whether Chris is an agent. There have been tons of accusations that he is an agent. He's an infiltrator. He appeared deliberately to disrupt the whole thing. I don't know. I don't have any proof of that, but this is what I do know, that he's consistently lied to you guys, and I've proven this over and over and over. But if he did it, he's a freaking genius. But I'm thinking he had some guidance with it, because his first video he published on his YouTube was the gentleman in court defending himself as a sovereign citizen. Then his next video, he started getting into the 1099 stuff and all the processes, and that stuff started gaining traction. So as soon as he threw up the video showing y'all that, oh, yeah, I'm a multimillionaire, bam, it just blew up. Okay. Then he created the Telegram group about a month later. November. Yeah, November. Because I, in December, went back and read every post from the very first post in Chris Hauser's Telegram group. Absolutely. Every one. Okay. If anybody can go back and look, you'll see through December, January, February, I post in there day number. And what I'm posting is days from the inception when Chris said, in 45 days, you should have your check. Okay, well, boom, there's 45. Here's another 45. We're on day 90, Chris. Boom. Hey, we're on day 120, Chris. Oh, boom. We're on day 165, Chris. Nobody's won yet, Chris. So y'all can go back and look at those threads. They're in there. I'm not in the group anymore, so it's not like I can go make that stuff up. So this is what happens. Okay. He came out, he created that. And if he designed this, he's brilliant, because he created an army of crash test dummies, gave y'all a list. Hey, here's a bunch of car dealerships that'll take 1099A. Y'all go pound these guys. So now I got an army to perfect the process to see if it works, or if it works. Then when he couldn't get anybody to get any good hits, he just went over and skim the cream of the crop, the real smart people who had some snap, put them in a separate group and didn't tell anybody about it. So anybody else asks questions, boom, you get expelled out of the group, right? How many of us got kicked out of Chris Hauser's group for asking questions or saying anything bad about Chris, right? Badge of honor. Same thing is happening in Patrick Marino's group. The exact same thing, okay? When you see a red flag, and it's just the same red flag you saw over in that group, run. Okay. I'm telling you guys, everything you need to know is free. It's free on the internet. All you have to do is pay attention, listen, get involved, ask the right questions to the right people. Okay. Don't believe everything you hear, and freaking do your own dang research. Clint, unmute. Come on. You're muted. You're muted. Hang on. Yeah, you're still muted. Hi, doggy. How you doing? You miss me? You want to say hi to everybody? Hmm? You still can't get it unmuted? Nope. See if that works.
There's that better?
Yeah, there you go.
Okay, I'm sorry about that. This first time I've done this on the iPhone for speaking on joining with people. So I've done it on the laptop, but so I'm kind of clueless with the phone.
I get it. Well,
Yeah,
well,
Floyd, Floyd,
welcome.
good looking out, man, because it's good that you're on the inside and you just revealed what you talked about the red flags. That's very important because Chris came out with a lot of very good stuff that seemed very palatable, but you don't really know the full story on the wolf until you get in there and you see where they start dividing the flock, so to speak, right? So that's pretty interesting. And plus, I haven't seen him on the scene in a long time. And the last I knew, he was going with he was doing something with the Treasury as some private banker or something.
Yeah,
Then he just
sign over 250,000 of your credits to me, and I'll get access to your Treasury Direct account. Yeah.
Yeah. So I was like, man, he just kind of disappeared, came in and out like a fart in the wind. So I didn't know what the heck happened there with him.
But he should just, go take care of Chris Hauser and not try to teach the world fallacies.
Well, evidently so. And you're right. We have to be very careful in what we're doing with this stuff because you don't know who's coming on the scene. And, they can be a flash in the pan, so to speak. And then poof, they're gone. There's been many like that. I've seen those guys over the years. And it does nothing but lead people down the wrong path. And a lot of them get charges and they don't know how to get out of them. And, they get hauled on down the road. And, whether he's an insider or not, I don't know. Couldn't verify that. But it sure does make you wonder.
Yeah, it makes you question a lot of things.
Yeah, it does. Now, Floyd, this other guy you were talking about, I'm not really too familiar with him, but he's, I did hear your announcement the other day. He's doing something like it takes you 7 weeks or what was it to do a trust?
He has a monthly subscription class. You get one class a week for 7 months to learn how to create your trust.
Oh my God.
At $300 a month.
Really? Wow.
Absolutely. Yes.
Well, good Lord. So evidently his trust must not have done him too bit of good because he's got to make all this money trying to teach you how to do one.
Yeah.
Right.
Yeah, absolutely. And all that lawful tender stuff he's pushing.
Good Lord.
Now they I did a video on this where they were doing the whole hoodie sale.
Right.
So they could get money to go to this seminar. Well, the seminar was Rourke's seminar.
Okay.
So now they are teaching subrogation.
Oh, okay.
I wonder where they got subrogation from. Rourke teaches subrogation. Oh my. So yeah, I contacted Rourke, told him what was going on.
Yeah, I bet he was just overly joyed with that.
First word out of his mouth, wow.
Hey, Floyd, you were talking about Riverside County, California. I lived out there for 20 years.
Really?
Riverside County.
Are you still there?
Nope, I'm in Iowa now. I was born and raised here, but after high school, I went out to California, Southern California with my sis, and I lived in Riverside for 26 years.
Wow. In the city proper?
in the city proper. I'm very familiar with Riverside County.
Okay, because she
I was a union electrician out there.
oh wow. All right. Well, your
So
brother.
I'm very familiar with Riverside County and its ramparts, and I know a lot of those places up in the high desert around Riverside County out there in those rural parts, it's desert area, and they get a lot of meth making activities in those parts.
Right.
Yeah, a lot of it's just open area. They can bring in their chemicals, they can do batches, and so it's known for that out in some of those ports. I'm not seeing that to discount what's going on here,
Right.
but in that area, that's where a lot of that happens. But there's some good areas too. So
Well, it's
just where you're at.
roughly 6,300 square miles. No, 63 square miles, which is 48 over 40,000 acres.
I believe Riverside and San Bernardino County, right next to it, they're the biggest counties in California.
Yeah, Riverside's gigantic. I had no
It goes
idea.
It goes all the way to the Colorado River out there on the border of Arizona.
Okay, is that Arizona? I thought it was Nevada. Okay.
Or it's they kind of intersect right in there. You got Nevada,
Right there, yeah.
right.
Yeah, by Joshua Tree National Forest. And
yeah, so Riverside, California, it's like a 3.5 hour drive to Vegas.
okay. How far is it to the coast?
Oh, it's Riverside. You're an hour from the mountain. City proper, you're an hour from the mountains, hour from the coast. You're an hour from everything. The sand, wherever you want to go.
Okay.
That's what's nice. That's what's nice about Riverside. You want to get some snow, go up to Big Bear, go up to Arrowhead, Lake Arrowhead. Those go up to about 8,000 feet in elevation up there. So they get snow in the wintertime.
Right.
And they got cabins up there and whatever. And so they got whole communities up there.
Okay.
And I think Santa even has a village up there, as a matter of fact.
Wow. Yeah, right.
Yeah. So it's quite a place, though. I mean, it's a lot of people.
Huh.
A lot
Yeah,
of people.
I want to go just to check it out and see.
Right.
I'm waiting on the plot. She said she was going to go down there today and get the plot for her land.
Okay.
That's what we're waiting on, so I can look at it and go, okay, that's my target.
Yeah, you got to see a little bit of brick and mortar right there, right? Something established.
Yeah. So, because when we give notice, these, they either got to join the team or they got to leave the property.
Right.
Yeah, leave the building, even if there's established business, which we don't want to do.
Right.
We want to break mom and pop and all that. We want to develop it, make it a better community. Because this whole project is not for my child, which is she's 23.
Yeah.
But it's for her children. And
Okay.
she doesn't have it yet. Okay. Because
Perfect.
the children in this community, they're going to have the private education. Okay.
Right.
One that we are now striving to have.
Yeah.
But they're going to get it the right way.
Yes, exactly.
Nutrition, athletics, law, contracts, everything, equity, everything that we need, trusts. They're going to know this stuff inside out.
Perfect.
They're going to speak multiple languages. Yeah. It's just straight geared, to them. They'll interact with animals, agriculture, aquaculture, off-grid technology, the whole 9 yards. Just
perfect.
Yeah, just strangle out, man. I'm so excited to put this thing together and be a part of it, and to be, such a unique cog getting this thing together. It's going to be fun because she already has artist renditions for the youth complex that she's going to build. This is for the school, but they have 3 NFL practice fields just to practice on.
Wow.
Yeah, they look just like yeah.
Wow.
And they have a stadium. You can imagine some of the biggest high school stadiums,
right?
Just like that. Community center, gymnasium for basketball. Very, very nice. Very well done. and it's all for the
Perfect.
kids. Now, for the adults who come, there will be classes, there will be online classes, modules for us to relearn, rethink, and how to adapt to the community and to the life that we're now living in the private side as we get out of the matrix and get access to
Perfect.
our, yeah.
Perfect. Yeah, this country's so in need of that. And it's like anything like that ever gets established, it comes into either a David Koresh kind of thing, and they
Right.
got to, we need something really legit that enforces the real rights we have in this country, that establishes that's not a corrupt son of a bitch, so to speak. You know what I mean?
Right. Yeah, it's bulletproof.
Good, honest, solid, God-fearing people, and the natural law and the natural rights and what this country was founded on.
Right. Absolutely.
So
Yeah.
that's perfect, man. I'm all for that.
Well, thank you.
All
It's
for it.
been a long time coming, and I was really disillusioned when I left Texas State Assembly. And I did take the cream of the crop with me. However,
Right.
Finding something else has been a task. This just fell into my lap because I did a video with James Lovett,
Yeah,
and
saw that.
yeah, and Madeline saw it. And the guy that she was association with was one of James's former peers or students, who's now a peer, and called James, said, "Hey man, I got this woman wants to do a video with you guys, or wants to do a Zoom with you guys."
Right.
All right. Had no idea who she was. And so we got hooked up on the Zoom. I didn't know the other guy. So I introduced myself. We started talking, and we were just, kind of chit-chatting, waiting on this mystery woman.
Right.
And her, how your little thing pops up on your Zoom to, let you know there's somebody else coming on.
Right.
And he goes, "Oh, there's Tiggle." And I went, "Excuse me, did you just say Madeline Clarice Tiggle?" And he's like, "Yeah." He goes, "You know Tiggle?" And I'm like, "You're kidding me." And
That's cool.
He's like, it's like, "No, you know Tiggle?" And I'm like, I have had hundreds of hours of conversation with this woman.
That's
And
cool.
yeah. And what had happened is so many people had her phone number that her phone never stopped ringing.
Okay.
And it was a number she had since high school, and she had to drop that number. And when she did, she dropped everybody.
This subject is properly
Right.
So
Sorry, I'm going
Only
to plug my in here. I don't want to drop my battery.
that's fine. Only a handful of people have her number now, and I'm privileged to be one of them. So that's how I got back involved with her and how she got here. This isn't something that she started working on yesterday or 2 weeks ago or last year. This is something she's been working on since 2008, every day of her life.
Wow. Awesome.
Yeah, there are no off days, there are no holidays, there is no 8 to 5. There's no,
Totally understand.
yeah, it's go, 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 go. This is her goal, and
Yeah.
she's got it bulletproof. And I'll explain to you how she inadvertently, happenstancely verified she is who she says she is.
Yeah.
Her daughter wanted a Tesla, so they went to Tesla,
Right.
and they're in California. So they told them, "Well, we're not going to register it in California. We're going to register it in Califia County." Where's
Okay.
that? It's in California. Well, you're going to register in California. No. We're registered in Califia County. That's a de jure county.
We're taking it out of the country.
And they're like, "Well, you've got to go get that approved by the DMV. If they say that Califia
Right.
County, California exists, then we'll do that." Okay.
That's cool.
We won't register the car. So, all right. So they go down the DMV, show them their paperwork. DMV goes, "Oh yeah, that's county."
Awesome.
Took
That's
it back,
awesome.
approved. Bro, I'm not kidding. I'm
Man, I
telling
want
you
my
guys,
own. Floyd, I want my own county.
you can do it.
I want it.
we're going to emulate this all across the country. Okay. I'm talking to people right now in different assemblies, different groups. I'm not pushing the issue, but as they come to me and we talk and they, learn a little bit more and they're more curious and we talk and they find out how advanced we are, is we have permission to create a diplomatic embassy, have diplomats, diplomatic post office.
Right. You got it.
We already have treaties with over 13 different entities, and there's, I think, 17 more pending for a total of 30, and there will be additional ones. And this is worldwide.
Nice.
Yes, we are recognized.
Nice.
That's what I'm trying to tell you guys. Okay. And the last thing that she was required to do was set up the court. And I showed you earlier in this video that there's the court system. That I developed that and the law enforcement structure. She already has a private security team she's contracting with, using them for private security, but they're going to take over the law enforcement division. I don't really know how they're going to fit in and work that. It's not really a concern. My deal now is I've set up the court system, so that's done. Now I'm moving on to the advertising, marketing, and the press release and public presentation. That's next.
Wow.
Yeah.
Wow. That's amazing, man. Congratulations.
Thank you. Yeah.
That's totally cool.
Yeah. It's not, hey, this ain't none of me. Somebody else did this. They don't want any fame, no fortune, no nothing. They have access to their account. They don't need anything. And they don't even want to talk in public. So when we do the press conference, yeah, well, it's just, she's done, Yeah. It's, I need to put the right people in place, and I'll just sit back and make sure they're doing the right thing. And that's what she wants to do.
That's right.
She wants to go sit out there in her rocking chair with her iced tea and watch her kids play sports. So,
you know what?
Cool.
Enjoy life and appreciate your accomplishments.
Yeah. And it's coming. Now she has been informed that if there are any other counties out there that are in debt default, that she can go in and take over that county and run it. And if they default on their debt paying her back, that she can absorb that county into her own.
Okay.
And they'll pay for it. Okay.
Wow.
Because they like what she's done. She's done everything correct. And so.
Nice.
Yeah, this is something very magical. Now, I'll pivot on that by my connection through Baby Trump, Christopher Ericks.
Okay.
I have a direct line into the Red MAGA Q Patriot Party movement.
Okay.
Those people are trying to do the same thing we are doing, but they're trying to do it through the political avenue. And as we all know, watching this, it's never going to succeed because the parties, two political parties, are two sides of the same coin.
Yeah, they are.
They're corrupted. They're never going to have a fair anything anymore. It's just technology, I think, has overwhelmed everything, especially with AI out on the loose now. No telling what's going to happen. Yeah.
In this game, if you don't have your roots and foundations to the very concrete below, you can just forget about it because there's too much at stake. Like you're saying, if you Republican, Democrat, they're a part of the same coin. But if you're trying to get into any of that route where there's other influences in it, it's going to undermine itself eventually. So you just will not even go there in the first place.
Right. Absolutely.
Do it bare bones from the bottom up.
Yep. And that's what she has done. And
good.
Yeah, when she called me almost immediately after they went to the DMV from Tesla. Yeah, she was like, "You're not going to believe this." I'm like, "What?" She goes, "We did this," and I didn't get the context.
Right. That you telling me that just opened up my whole mind on some ideas with that. But I sure would like to know the inner workings of that. Just not for my own selfishness, but just to know to make it possible to create. If something else need to be created to go along with another county, then we could all join and be a bigger, that's my lines of thinking on that.
This is going to be blueprinted and it's going to be
Okay.
implemented across the country. Okay.
Perfect.
But it can only happen in the right communities,
Yes.
the ones that can accept it. Okay.
Yeah.
You definitely don't want to take this to downtown Chicago
No,
or
no, no,
Detroit or Philadelphia or
no,
San
right.
Francisco.
Yeah. Well, now, Floyd, my question is this. My question is this.
Uh-huh.
To even start any of this, you kind of have to go along the lines in your territory. Does it basically have to be started out with, you have to get your land patented?
You definitely have to have your land,
Does it have to be under patent?
meridian, meets and bounds.
Okay. Okay. That's what I figured.
And yeah, and I don't know the exact process, but almost every time I talk to her, she gives me some new thing that she has done to protect herself. And it's
Right.
yeah, she's done stuff that most people haven't done yet. I haven't even
Yeah.
thought,
Now,
I haven't even seen it.
now, Floyd, I'm in the Iowa de jure Republic,
Okay.
close to the state of Iowa, I will say.
All
I'm
right.
not in the state of Iowa, but I'm by the state of Iowa.
Okay.
Anyway, so I had a bright idea, thinking off the cuff and out of the box. Is you get in agricultural areas, and then in Iowa, and they have them in other states, but they have a brand. You can apply for your own brand.
Huh,
And,
that's cool.
right. And then, so I was thinking about getting a brand patent, and then I could tattoo that on my body so they could never throw you behind bars because that's my brand property.
I guess that's one way of doing it.
You know what? I mean, I'm serious. That really is feasible. I was researching that,
Uh-huh.
and I'm telling you what, even if you didn't want a tattoo, you got an earring that says your brand mark on it. You know what? Sorry, officer, but you can't take me behind the bars, because I'm driving without a license or whatever, because you're interfering with my brand and my property.
Right. Yeah.
I'm telling you, this whole thing just opens up. And I just said that because, what you're talking about. I mean, I had this idea and I really started researching it. I'm thinking, you know what? That really is feasible. Because they would be liable for taking someone else's property. Because if they're calling you the trust on legs, well, let's go ahead and play that game. Let's roll the dice. You want to pull my brand in and you want to be stealing someone's brand? Well,
Right.
guess what?
Because you are the brand.
I am the brand. And guess what? I've got the mark on my body and it's already patented and it's in the registration.
Boy, this falls right into what we were talking about earlier. Those print out? Oh, I gotta print those out. Okay. Yeah,
So anyway,
I've got something else, and it's not my process. It is James C. Lovett's process, the bad wolf.
no, I love
who
I
has
love
shared it
James.
with me. Okay. But I don't know when he's going to release it. I imagine he's going to release it when he completes it, and he will complete it because I'm a part of it. But when he does that,
Right.
freaking blow y'all's guys' minds. I mean, you're like, what? He did what? Yeah. Yeah. Yeah, he can do it. It's gonna be, they're all gonna trip. So yeah, I can't wait for that. It was supposed to already be done, but they kicked it back and he had to do something additional. So that's what we're doing now to effectuate that process.
Yeah.
But
Yeah, I can't. That James, he's a stand-up guy. I really like James. He's
James,
a good.
awesome. I love
Yep.
James to death. We are definitely brothers from another mother.
Yep.
But before I go on, okay, now, as always, I tell you guys that what happens in my life is divine. There's no other explanation for it. I just, if I was still an addict and drugs and drinking and chasing women and all that, all these opportunities that have come before me, I would just totally overlook, like
Right.
I did in my youth. I just
Okay.
missed. God, I don't know how many opportunities. It hurts me to even just start thinking about them. But anyway,
Tapping to the best of us, Floyd.
Right. This is the Holy Bible. And,
Yep.
here it is, just to make sure that, it is what it is, right?
Yep. Yep.
It's big bullshit. So there's my right hand. Okay. There's my left, and there's my right. And as always, I swear to tell the truth, the whole truth, and nothing but the truth. So help me God. So when I tell you guys what Patrick Marino is doing to you, and it's going to affect your life in a bad way, coming from my heart, honest to God's truth. If you can get Patrick Marino to answer your questions, holding a Bible after he took an oath to tell you the truth, whether you're doing a private consultation, you're on his chat, ask him any question you want. And I don't think he has the balls to do it. And if he does, I don't think he believes in the Bible.
Yeah, right. Yeah, that's stand up, Floyd. That's stand up right there. That's good.
That's how I roll, man.
Well,
I used to be a piece of shit. Okay. And I made a decision I wasn't going to be a piece of shit anymore. And I needed to, reinvent myself. And this is who I am. But my past made me the man I am today, gave me the knowledge, the research, the resources. Everything I know, I learned on my own. I didn't learn it in school because I dropped out after third grade mentally. I kept going, but I was so far behind because of, other issues. I just quit and I winged it. And I have no idea how they gave me a high school diploma, but I got one. And, I've got some college and some degrees, but no big deal. But all that self-taught, all the legal stuff, self-taught. Nobody sat down at the law library with me and said, this is how you do it. This is how you write a writ. This is how you write an affidavit. This is how you write a petition for writ of habeas corpus. This is how you do a petition for writ of quo warranto. None of that. I had to go look all that up. And I was filing petitions and writs that fucking nobody had heard of. Yeah. Bro, when you're sitting in prison with a baby, what they call a baby life sentence, 60 years, you're looking for the kitchen sink, the bathroom, the drain, the shower, scrub brush, whatever you can throw at these people. And they weren't hearing it.
Right. No. Yeah, that's so cool. I'm in the same boat with you. I'm self-taught too, but I've got a lot of good mentors. Like I've said before, Gene Keating. I love Gene Keating.
Yeah.
And then I'm glad to be hooked up with Wolf now because I follow Wolf. He's a great guy. James Levitt.
Genuine.
And then,
from the heart.
Yeah. So, I mean, Gene Keating for me has been one of the bigger influences that really, and I think it takes different ones for different people. I'm not saying he's better than anyone else, but for
absolutely.
When I ran across Gene, somehow he just got the Clint, and so he's the one who kind of tripped my trigger, for me to get into all this. So I kind of go along his lines and focus on the commercial stuff, the taxes, and just get to the root of the problem and get rid of all the rest of this BS. Now, I did expatriate, and I did file it to the 5 officers of the corporation.
Right.
So I'm a state national. Technically, I am. I mean, because I did that. So, and I couldn't wait to do that once I found out the real truth and what you need to do. But that's my personal thing. I'm not saying everyone has to do that, but that's what I've done. And I'll tell you what, it just totally gives you a different mindset on freedom and what's available to you, how you're supposed to act and how you're supposed to be. And you know what? The biggest part about all this is being responsible.
Right.
It's responsibility. And then, like James Levitt says, being self-governed. And that takes responsibility. So it's not all about getting free so you can go out and create a bunch of havoc and then even like in Chris Hauser's situation, you start throwing liens at all these big wheels. Well, you know what? You're going to mess with the bull, you're going to get the horns. So we're not out there to create controversies. We're not out there to go step on things, but they will come to us, and it's good for us, to know how to defend ourselves and to act properly in those situations. And the most thing I've learned, Floyd, is to remain in honor.
Yep.
That's a big thing, is remaining in honor. And so now I was in court once a few years ago, and I was in there for an OWI, Floyd. And guess what? I first started learning about this stuff.
What's
And
a
guess
what's
what?
an OWI?
Well, an OWI is a drunk driving charge. I got pulled over for an expired license plate, and then I was drinking that night going on the way home, and so they got me for a drinking and driving charge.
What's the O stand for?
The
Operating.
OW operating while intoxicated. That's what it's called, Floyd. That's what it's called in Iowa.
Okay.
So
That's
guess what,
funny.
Floyd? Floyd, now listen to this. I went into that court and I went in there by special appearance. Okay.
Uh,
I went in there by special appearance, but I didn't know a whole lot. And then I even told the judge, well, I would like to do subrogation in here. And I didn't even really know what in the heck I was talking about with that. And then she said, well, Mr. Squire, how do you spell your name? And I told her it's lowercase this, lowercase that, lowercase blah, blah. And you know what? When I went here by special appearance, they put me down as a plaintiff then. And that did get recorded. I did get the plaintiff position when I did that. Now, but this is what I did wrong. She jumped back at me and started, well, you're not doing ecclesiastical law and all this other stuff, because I was going off a little bit. And then what I did, I just lost it and fired the judge. I fired her 3 times and she got up off the bench and went and got the bailiff.
Oh,
This
no.
is the story. And so I spent 30 days in jails for contempt of court for firing the judge. You want to talk about learning the
Did she
hard way?
sentence you, or did the next judge coming in sentence you to contempt?
No, I just stood there and waited with the district attorney, and I was going to walk out, and I said, well, the captain left the helm, so I'm walking out.
Oh.
And the district attorney said, well, I said, she abandoned the ship. That's what I said.
Right.
And so the district attorney goes, I wouldn't do that if I were you. Me not knowing no better, I just stood in there and I just waited for the officer to arrest me. But yeah, they hauled me down and I got 30 days in jail for contempt in court for that.
That sucks.
So I've learned the hard way in some areas, you know what I mean? I started out all ticked off at the world and I know the truth and blah, blah, blah. But there's a way of going about it. You don't just kind of go off and, I know you're right. You think you're rightful and you have the right standing, but you still have to do the right performance in there because it'll tie you up.
Right.
So
yeah. That'll tie you up.
That's literally. And that's a little bit of, Floyd, I'm just coming clean right off the cuff. That's a little bit of my experience, starting out.
Right. Yeah.
Yeah.
I tell people, man, when y'all get these traffic tickets, man, that's Warriors playground, man. Y'all need to take those to jury trials and just, because the worst thing that you do, you pay the fine.
That's right.
Okay. Or the cop may even show up for the jury trial and then boom, you get dismissal because, 6 months later, he's doing something else. Yeah, exactly. Right. Yeah. Those are the times when you want to press those boundaries and start working it because, the penalty for that, it's just a traffic ticket, but you're still working the system and learning it in that process. Yeah. You're paying for your education.
That's right.
Yeah. And the reward's greater than the risk.
That's right. And just in that OWI case I was in, operating while intoxicated, I learned a lot just going through that.
Right.
So that was a good thing for Clint,
Right. Yeah. I'm an expert in DWI, so.
Well, I know that's what you said, but that's why I wanted to mention that because I'm like, I've had a little bit of that, Floyd,
Yeah, because up until about 2012, I read every DWI case from the state of Texas and any other state I could get my hands on.
That's cool.
Yeah, well, it's not cool. It's just, I had to, I'm looking for the, changes in laws, anything that'll affect, man, I threw everything at these people.
Right.
I'm under the health and safety code.
Right. You gave yourself a little college education right there.
Yeah, I actually, once I got sentenced, I was sitting in county jail. I was like, oh, man, 7.5 years to come up for parole.
Wow.
Do you want to fight your case, or do you want to go get in college and get your master's degree?
Right.
You know, and I made the choice because the day, a week before I went to trial, was my daughter's third birthday. And I dropped her off on her birthday on the 10th, and 22nd, I was found guilty. Then August 15th, I was sentenced to 60 years, but I was taken into custody after my conviction. So
Right.
I didn't see my daughter for 14 years, over 14 years.
Oh, man.
Yeah,
I'm
until
sorry.
she graduated from high school.
Yeah. Sorry to hear that, man.
Oh, but hey, it's cool, man. For my background, statistically, she should be batshit crazy, be a hooker, hooked on fentanyl, meth,
Right.
crack, all that shit.
Yeah.
Day before yesterday, she got her master's in anthropology at SMU, for anthropological pharmacology. And
Wow.
she has 2 more semesters to get her PhD in psychology.
Wow. Good for her.
She is a remarkable woman on her own, not even as my own daughter. I mean, if you think I'm smart and intelligent, oh my God, she's wicked.
She sounds, he sounds like it.
Yeah, she is. And she is into psychotropics and psychoactive substances and
Right.
healing in that manner. And that's her platform. And she is going to be somebody in that arena.
That's
Absolutely.
great. That's
Yeah.
great. I'm happy to hear that.
Very, very,
That's,
very proud.
yeah, that's awesome, Floyd. That's good, man. That's good to hear.
Yeah. She's got her head screwed on straight. As soon as I met her when she's 17, I was like, oh, thank God I don't have to worry about this girl. She's going to make it.
You're right. And you know what, Floyd, I'm going to say this, concerning the Bible, because I'm a good believer in the Bible. But one good thing to always know is, when you follow God, it seems like you do yourself. What the devil means for harm, God will always turn into good. When we look to Him for the answer, He'll turn it all into good. And it sounds like to me that's exactly what happened with your daughter in this situation.
Yeah. It's done. I'm so grateful.
Yeah.
I'm just blown away how
Yeah.
magnificent she is, just all around. Beautiful, intelligent, bright, vibrant, curious. I don't think she ever went to a spring break. Her spring break was going to the library to get books or going to, some extracurricular thing at Duke University or Yale or she spends her summers at these other colleges taking this other stuff. Yeah,
Wow.
oh yeah. I mean, I was like, you're doing what for spring break? Check out some books. Like, you're not going to like South Padre or Cancun or Acapulco or something, but well,
Yeah, it's like, well, yeah, don't you want to have a life and have some fun,
no, she didn't want to be like her mom and dad.
Yeah, right. That's
Yeah.
funny how that pendulum swings like that.
Yes, and I'm so grateful it swung that way for her.
Yeah, right.
Yeah,
Yeah.
she's an awesome girl. So anyway,
Yeah.
enough about my wonderful daughter.
Yeah.
Yeah, anything else you want to touch on?
No, Floyd, I just wanted to come on here and get introduced to you a little bit. I get on your chat and you get me going and I start putting in stuff. And I thought, well, you know what? I'll just get on there and say hello and just kind of let people know who I am. I'll be around and, we get into some other subjects and we'll get on to something. I'll chime in. I'm kind of spontaneous like that. I
Okay.
flow like that. It's kind of with spontaneity. So
Do you have a
but
specific topic or a process or something that you're very experienced in that you'd like to share?
well, one thing I was talking about tonight, even like in the Christopher Hauser deal, you go messing with the bull, you get the horns, and he was in a, he picked with the commercial bull, so to speak, and so there wasn't no jurisdiction issue that was going to get him out of that mess. And you
No.
said that well. but really, it's what I learned from Gene Keating. The real word wouldn't be jurisdiction in that situation. It would be venue. Venue would be the deal. Now, another good thing about being behind bars.
They addressed the venue because of the whole sovereign citizen. They addressed the venue issue. They tried to get a change of venue because of the sovereign citizen incident that happened in Knoxville. It was unrelated to them. They were in jail at the time awaiting trial. But this incident happened like a month before trial, and there was this big, sovereign citizen, and they had already been on the I think on the front page of the USA Today.
Okay.
About being sovereign citizens. So the notoriety was already there. So they were trying to stop. So they were trying to get the change of venue to another county. And that got knocked down by the judge. However, they never challenged it again beyond the Court of Criminal Appeals. They shut that down quick.
Yeah, it's funny, Floyd, because I think that whole thing got started off onto the wrong foot anyway. So they were already pretty much caught in contract, so to speak, through their actions. And so they were subject to that venue and jurisdiction then through all that situation. So there was no working their way out of it at that point.
And they admitted it on the record that they filed these UCC1 liens.
Yeah. Right.
Yeah, every one of them admitted it. And then I'm like, you admitted it, and now, in a trial, a jury trial. And then now you're appealing it? Oh,
well, this is what got me going, Floyd, and I'll talk about this. The only thing that would have got him out of that situation be the standard form 28, 90, 91, then the bonds at 24, 25, and 25As.
Right.
That'd be the only way that they would have got themselves freed up out of that situation. And I've got mine all written up right now and drawn up, and I'm just keeping them just in case I ever need them sometime. Because to my understanding, those forms, the trilogy of the 28, 90, and 91 releases you from escrow out of the warehouse receipt that they hold you on through the birth certificates and all that.
Right.
And then you pretty much, you leave those blank and you just put the last four numbers of your SSN numbers on those bid, performance, and payment bonds. And then you can file those in the case like 30 minutes prior to the case. And then you also take a set of those sealed copies into the judge. And then you hand it to the judge, during the arrears or whatever situation you're in.
Right.
So that's the best way, to my understanding at this point, through my studies, to get yourself released from any of those kinds of situations like that. Because what they're doing is through the Electronic Signature Act, they're taking our signatures. When you sign for something, whatever it is, oh, thank you. And now they get to use it to put on those bonds. Right. Now
can you give me your signature, sir?
Yeah, right. Can I have your name, please? Can I ask for your social? That's how they'll put it too. No, you can't have the last four of that. Matter of fact, I don't have a social security number. And guess what? You're not lying either, because that's your trust social security number. That's not yours.
Right.
So anyway, yeah, the main thing I'd like to talk about was just bonds.
Just he's over here laughing.
Yeah. I mean, just those bonds, that's your e-ticket to getting out of those situations. And you don't know those, I would recommend anyone to start familiarizing yourself with those, because those are very powerful. And those assumption out, for them doing that for you. When you show up and do it for yourself, now you're not committing your own self behind bars for whatever the situation is. If it's a crime.
Yep.
And all commercial, but we have limited liability. You can't go out and murder people. You can't go out and be a serial killer. But if you're under the commercial venue through commercial crimes, then by all means, these bonds will work for you. By all means. So I would recommend anyone looking into those. But and I'll just leave it with that, Floyd. I think that's a good subject to leave it with.
Yep, absolutely. And if you want to see those, I did a video series and playlist on the GSA bonds. So you can go check it out, see how they're filled out. And then I did another one on where all to send them.
Awesome, Floyd. I didn't even know you had those, but I'll check out your video on them and look at what you got.
Yeah, I think I did my 300. This is the 328th video that I've done.
Wow, that's cool.
Yeah.
Good
Yeah.
deal, man.
Good enough to get me on IMDb. So
That's cool, Floyd. You know, keep up the great work, man, and you keep
Thank
on
you.
doing. And we'll stay in touch. I want to find out more about this county thing and all this.
Oh, you will.
You got me curious.
I'll start doing live YouTubes just like this.
Okay.
And I will bring Madeline on and she will speak and introduce herself and talk to you guys. So look forward to that. I don't know exactly when we'll get that established. I'm kind of getting caught up with all of my stuff. I will be moving soon. I just don't know when and where quite yet. So that's going to be in play within the next 21 days. But after that, once I'm on firm soil, I'll start doing some more regular stuff and having guests on. I'm currently watching all the tutorials for the YouTube Studio Creator, so I can start editing, start posting notifications that, you know, on such and such date and time, this video is gonna be premiering. So
Awesome.
yeah,
Awesome.
and editing. So yeah, we'll get all that. And you, Clint, you more than welcome to come on anytime. Open invitation.
Yeah, thanks, Floyd. I appreciate it, man. That, you know, this is what makes the world go around. We all work together at all whatever levels we're at, and we compare notes and encourage each other. That's the most important thing.
Right. Yeah, you have to lift each other up, you know, help each other as much as possible, help out your fellow man. You know, no harm, no foul.
That's right.
Yeah. And as always, there is an open invitation for the man of the hour, Christopher Allen Hauser. You, as always, have an open invitation to come on my show.
That's good.
Patrick Marino, he has an open invitation to come on my show. Absolutely.
You know what, Floyd? Floyd, now that's being honorable right there. That's being honorable. That's good.
Yeah, I've been begging those guys to come on my show. Please come on my show. Like I'm going to ambush you with anything. You already know everything I've got.
No, right. You know, that's very honorable. You know, everyone has a right on a platform to talk about their situation and defend themselves or whatever it may be. Set the story straight, and it's honorable that you're giving them that platform, because you know what, Floyd, a lot of people won't even do that, and that's sad. Yeah.
Well, you know, I like I said, I try to walk in honor, good faith, and clean hands at all times. Everything I do, every decision I make, it weighs on me a lot that, you know, people disappoint for some reason in the last, you know, and I think it started before COVID. People are getting stupider.
Oh, yeah.
Dumber.
Yeah.
And I'm just like, you know, how do you people make it day in and day out? I mean, you're just dumb as a fucking box of rocks.
You know what, Floyd? It's a sign of the times we're in. I'm telling you, we're in those times, brother, and it's a little sketchy out there.
I know. How old are you, Clint?
I just turned 55 last March.
55. Okay, so you caught part of the good times. I'm 61, so you know, I was born in 62, so I got to live the 60s, the 70s, the 80s, the 90s, and you know, I'm gonna say my generation, we lived the best of life. You know.
Yep, absolutely.
Yeah, best freedom. I mean, we could go anywhere, everywhere, 24/7. Didn't have to worry about pedophiles, sexual predators, and you know, drive-bys and gunfire, and you know.
Yeah, it's scary, man. Every time you walk out the door, you're walking into commerce, and you don't even have to walk out the door anymore. You got commerce right in your own room because you got all the devices with you to do it.
Yeah.
We didn't have that growing up, did we, Floyd?
No. You know, if you'd have told us all this crazy stuff, you know, when we were children, that would it be happening right now? You know, we'd have probably never stopped laughing.
No kid, right? Hey, remember the size of the calculator when we grew up when it first came out?
Yeah, right. You can't carry that around with you everywhere for the rest of your life.
You got laptops that are smaller than calculators.
Yeah, yeah.
I'm holding one in my hand. It's called a cell phone.
Yeah, yeah.
Unbelievable.
Yeah,
So,
crazy.
all right, Floyd. Well, we'll
Okay,
talk
my
more
brother.
later, man. It was good
Yes,
chit chat.
sir.
Thanks for
Thank
inviting
you
me
for
on.
coming on. I appreciate it. You have an awesome night.
Anytime, my friend. We'll talk soon.
Yes, sir.
All
Thank you,
right.
Clint. All right, kids, man. Thank you. I want to appreciate Clint coming on. Sorry I didn't have Patrick and Chris Hauser join me as well. But if you'd like to reach me, you can always reach me at the Fearless Floyd Show at yahoo.com. You can go to my website, the Fearless Floyd Show at Yahoo, not Yahoo, fearlessfloydshow.com. I don't know what I'm doing. I'm losing my mind. And there we go. So leave a comment below, like, subscribe, share, hit that notification bell if you want to know when I put out new videos, which is not quite often, maybe once a week now. I might do some more twice a week. So Clint's gone. Nope. All right. So I hope you guys got a little education in this video. It's not my purpose to save everybody, but if I can save one person, I've done my job. I did what I'm supposed to do. My heart is content by doing that. And I think I achieve that every day. That's all I'm about. Trying to save you time, energy, and money. Okay. Because those three things you can't get back. Don't get caught behind the 8 ball and lose 3, 4, 5 months of time, money, and energy that you could have been expending elsewhere and get a better result or more fruits for your labor. So if you're still in Patrick Marino's group after this video, I feel for you. If you're betting and counting on his process, his information to save you from eviction, to pay your bills, to save your home, to pay off your mortgage, to pay off your car, and you lose everything or to lose that item, you deserve it after today. I'm going to tell you that. You continue to enroll in his subscription for trust classes. He says takes 7 months to teach you and get set up, getting ripped off. Subrogation, TWIA, Trading with the Enemy Act. That's Rourke's process. Rourke and Boris. It's not Patrick's. Patrick went and took a seminar, took his little clique with him, got all the information. Now they're coming back and putting it in their package. Okay. Subrogation is difficult, kids. It's not easy. So don't think it's a simple process. And he picked it probably because it is so intensive that it would cost you a lot of money if you're under a subscription program. That you'd probably do a 1-year subscription for the subrogation process. So you're paying $300 a month in subscription fees. Really? You're going to pay all that? Why don't you just pay like the $1,200 or $1,500 and go to Rourke seminar and learn it from Rourke yourself? If you'd like to get in touch with Rourke and go to Rourke seminar and get it from the horse's mouth, contact me. Send me a DM, fearlessfloydshow at yahoo.com. Leave a comment below. I will contact Rourke, find out when his seminar is, and I will send it to you. You can contact his host or his hostess, who he used to have. I believe he ran his own seminar this last time, and get enrolled and go to his seminar. Why do you need to pay Patrick all that money to learn secondhand information when you can go straight to the source? Because Rourke generally holds them 4 times a year. Okay. He generally holds them right here over I-10 West in Katy, Texas. Okay. At a hotel, and I'm not going to mention the hotel name. I've been there multiple times. Even did birthday dinner at the final night on a Sunday night with Rourke and all the seminar attendees. Absolutely. That's where I met Rourke. So for all you kids out there who are really serious, really want to know, go to Rourke's seminar. Don't get it from a bunch of secondhand bozos who don't know their ass from a hole in the ground. All right. I'm just telling you, kids, I'm right. I've been right. I keep telling you guys. Okay. And if you don't want to listen to me, don't listen. If you lose everything, don't come crying, send an email to me, Bad Wolf, Brian Pastor the Way, Eric, Sergeant Authority, JW, anybody in Telegram, whining about how you lost your shit, you're facing foreclosure, your car got repossessed, your credit card got shut down, all because you used Patrick Marino's processes. First thing out of their mouth would be, Fearless Floyd warned you, didn't he? You got your just desserts. Got what you asked for. You didn't listen. So, for all of you out there who are going to continue to support Patrick Marino and his little clique of scammers and grifters, more power to you. Keep supporting him. I hope y'all make him a multimillionaire. Okay? Because you're not going to become multimillionaires like him, because multimillionaires don't need money from other people to teach people other stuff. Okay? I don't really need money. That's why I don't teach anything. You want a private consultation? You want to pick my brain? Yeah, I'm going to charge you for that. Okay? That's why when I do Ann's classes, those are Ann's classes. That's Ann's curriculum. It's not mine. When I get asked a question, I vet the question with the caveat that the answer I give you will be Ann's answer. It will not be mine. It will be not my opinion. This is Ann's class, her curriculum. So it's Ann's answer. It's her stuff. That's how I roll. So if you want to get a trust, you can take the class. It's $199. And 1 week, if you got any kind of snap, modicum, then motivation, you will have your trust set up. You'll have your EIN for your trust, and you will have your non-interest bearing bank account established. 1 week. I've had students do it in 1 week. Absolutely. So if you think it takes 7 months to learn how to create a trust and get all that done, look in the mirror. Do you see a box of rocks? That's what I see. All right, kids, y'all have a good night. Appreciate you being here. Chris, again, you're welcome on the show anytime. Hit me up, fearlessfloydshow@yahoo.com. Patrick Marino, you got my number, baby. And we're going to be looking out for those